The August 15th, 2024 hearing for the Planning and Land Development Regulation Commission is now called to order. And if I could please have you silence any audible devices that you may have. And if you could please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning, everyone. I would like to thank everyone for joining us this morning. And Ms. Tucker, could I please have a roll call?
Good morning, members. Member Craig?
Present.
Member Shelley?
Here.
Member Costa?
Here.
Member Patterson?
Here.
Member Sixma?
Here.
Chair Mills?
Here.
And our county chair representative is currently vacant.
Okay, thank you, Ms. Tucker. We do have minutes from the June 2024 meeting and the July 18th, 2024 meeting. Is there any discussion on those minutes? Hearing none, I'll entertain a motion.
I'll make a motion. I can enter them both at the same time, correct? Okay.
Yes, you can.
I'll make approval for amendments on minutes June 20th and July 16th to be approved.
That's July 18th.
Or July 18th?
Yeah.
Yeah, July 18th. Okay, amended.
Okay, I got a motion on the floor to approve the minutes for June 20th, 2024 and July 18th, 2024 from Mr. Sixma and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion carries unanimously. Okay, if anyone would like to speak for or against any of the cases being heard today, if you could please fill out a form at the back of the dais and hand it to Ms. Tucker to my immediate left here. And we will be limiting you to a 3-minute time limit. And after the comments have been heard, I will give the applicant an opportunity to address any concerns the speakers have and answer any questions the commissioners may have. And at this time, I'd like to turn it over to Mr. Soria for legal comments.
Thank you, Mr. Chair, and this is for members of the audience, that decisions by this body on special exception cases and cases which rezone real property from one classification to another pursuant to the zoning ordinance are recommendations only to the county council and do not constitute a final hearing. New evidence may be introduced at the county council public hearing. Decisions on variances made by this body constitute final action subject to an appeal to the county council. And what this means is that no new evidence may be presented at the time of the county council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. Hearings by this body on rezonings, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent substantial evidence in the record, and competent substantial evidence has been defined as that evidence a reasonable mind would accept to support a conclusion. Thank you, Mr. Chair.
Thank you, Mr. Soria. And while on legal comments, I would like to ask the commission to disclose for the record any ex parte communications that have occurred before or during the public hearing at which a vote is to be taken on any quasi-judicial matter. And I'll start with my immediate right with Ms. Craig.
I have none. None.
None. None.
And I have none. Okay, we do have a request for a continuance on ordinance 024004 from staff. Ms. Smith, would you like to comment on that?
Yes, sir. This ordinance needs a little bit more work, and it will be scheduled next month. We'd like to continue it till September 19th.
Okay. Would somebody like to make a motion for me, please?
I'll make a motion that we continue ordinance 024-004 until the, what was it, September?
September 19th.
September 19th meeting.
Okay, I got a motion on the floor to continue 024-004 to our next meeting of September the 19th from Mr. Costa and a second from Mr. Patterson. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, we're going to move right into our new business. So, Ms. Shelley, if we can get started, please.
Yes, sir. Case number V-24055, variances to the minimum yard requirements on urban single-family residential R4 zoned property.
Okay, thank you, Ms. Shelley. Ms. Ray, this one's yours.
Good morning. The applicant is seeking variances to complete a lot split and resolve code violations. Variances 1 through 3 are for an existing single-family residence. Variance 1 is to reduce the east front yard from 25 feet to 19.7 feet. Variance 2 is to reduce the north front yard from 25 feet to 19.9 feet. Variance 3 is to reduce the south side yard from 8 feet to 5.9 feet. Excuse me. Variances 4 and 5 are for an existing carport. Variance 4 is for the east front yard from 25 feet to 9.7 feet. Variance 5 is to reduce the north front yard from 25 feet to 6.7 feet. Variance 6 is to reduce the north side yard from 8 feet to 4.1 feet for an existing wood deck. And variance 7 is to reduce the south side yard from 5 feet to 1.5 feet for an existing metal shed. The applicants purchased the property in March of 2022. In December of 2022, a code complaint was filed and code violations were issued. Currently, the property is developed with 2 single-family residences, 2 accessory structures, and 2 metal sheds. A subdivision exemption to split the lot and to create 2 legal parcels was proposed as a resolution to the violations. Applicants applied for the subdivision exemption in May of 2023, and a notice of intent was issued pending the variance requests to the existing buildings. Staff's recommendation for variances 1, 2, 3, and 6 is for approval as it met 5 of the 5 criteria. And variances 4, 5, and 7, recommendation for denial as it failed 1 of the 5 criteria. Should the PLDRC find that the applicant has provided competent substantial evidence to support approval of the variances, there are 6 conditions provided for consideration. I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? Hearing none, is the applicant present? Good morning. If you'd come forward and state your name and address for the record, please.
Good morning. My name is Jennifer Aldreche. I'm from Easer Law. My address is 508 North Harbor City Boulevard, Melbourne, Florida 32835.
Okay, you've heard the staff report. Is there anything you'd like to add to that?
Yes, I would like to add to that, please. Just to give you some background information on this property. This property lot is very unique. It's a angled corner lot property. There isn't a lot of records or history on every single structure that was built on this property. My client received it from a beneficiary from a trust. The trustee who initially owned all this property owned it since, I want to say, hold on, I have that here. They owned it since 1989. So before that, I'm not sure what structures were there before the original owner had it. She put it in a trust. It was transferred to her daughter. Her daughter only owned it for about 2 years, and then she sold it. Now my client now owns it. When she purchased it, she wasn't aware of these code violations. She just thought, this is a really nice lot, has really nice buildings on it. And of course, there was some code violations, so we were hired to represent her. Majority of the variances are part of a lot split that we have submitted an application for because there's too many dwelling units on the lot, right? So we have to split the lots in 2, so there's only 1 dwelling unit on each lot. So obviously it's going to occur some issues with setbacks, and so this is why we need the multiple variances. I did sit down and have a meeting with the county so we can discuss this lot because of the various issues. And moving forward, the best plan was to split the lot and apply for these variances. According to my client, based on the history of the carport, because I know the carport is one of the variances that the county believes this is not in didn't meet the criteria. It is our understanding that at some point there was no paved road, and part of the paved road was part of the property of the previous owner. And when that road was paved is when they took some of her yard, which caused the carport to be so close to the paved road. There's no record of it, like the county said. There's a lot of structures here. The majority of the permits we found were for fencing. I was able to locate the permit for the second structure, which is the 2-floor. And on the permit, it does show that the carport and the little, on variant 7, the little shed was there. And to give you some background information on the shed is not really a shed, it's more of a cover. There, inside that shed is the water well, and there's also a sprinkler system, and there is a generator. That's all that covers, that's covering. There's no shed, there's no actual storage in there. It's pretty much like a cover. There's no record that it was constructed in 1995 or 1997, so it's really hard to say whether it could have been in compliance with the ordinance at that time. Again, all these structures have been on this property for over 20 years, and not once has there been any violations or, complaints. When looking at all the conditions, whether if the property has a special condition, I believe all of the structures, all the variances here meet that requirement. This is a unique lot, as I mentioned before. It's been in this condition for 20 plus years. The shape of it, we don't know what ordinance it passed. Ordinance were in place when any of these structures were actually put on the property due to all the issues with the record keeping. I believe, I think when I initially spoke to the county, some permittings were processed through the city, some through the county at some time, and that's why there was missing records. I did have to make a public records request justifying the one permit. When it comes to special condition and circumstances that do not result in action of the applicant, again, my client purchased this property as is. She has not added to the property, she has not taken it away. This is how she received it. And again, everything has been on here for 20 plus years, right? When it comes to, let's see here. The element of whether, the minimum requirement, we're not asking for anything more or anything less. We were able to get a survey. And in the survey, we were able to measure the exact amount of feet and inches needed to comply with the variance. The minimum requirements, she's not asking for anything more, nothing less. This is the only thing we're asking for. And this would not deprive anyone else from enjoying their property. There's similar lots in the area that have structures, and my client would have to suffer an undue burden to bring down the carport, bring down the shed, make any changes to the land, because these structures have been there for 20 plus years. Again, these structures were here, permits were submitted to the county, and the county was aware that there was a shed, that there was a carport, that there was this little apartment on the side that is no longer an apartment. And so the county was aware, and they never ever brought a red flag to our client or to any of the prior owners. Again, I don't know what was going on at that time. It's really hard to say because the record isn't clear. So my client's just asking for the variance approval for these seven variances in order for us to get approval for the lot split and pull permits for and all the structures that do not have permitting, and validate everything that's on the property standing today.
Okay. Any questions for the applicant? Mr. Costa.
Good morning. Before I have a question for her, I'll have a quick question for staff. I don't see it on here. Typically it is. The setbacks on this is what? Front yard, backyard, side yards, please?
So it is zoned urban single residential R4. So the front yard setback is 25 feet, and the side yard setback is 20 feet combined with a minimum of 8 feet on any one side.
Minimum of what? 8 feet
8 feet, yes, sir.
on one side? Thank you. This is a corner lot. You have 2 front yards, technically,
Yeah.
per the code, right? So my question is, have you looked at the package that they put together here?
Yes,
And-
I have.
And have you looked at the staff recommended conditions on page 6? And you're in agreement with all of those?
Page 6 of the report. Oh, sorry, I'm looking at the wrong tab.
Yeah,
Give me
page
one
6 of
second.
19.
Yes. Sorry, it's 19 pages. Yes, I'm aware of the recommendations.
And you're okay with all those?
Let's see. Yes, if this was except for the denial of variance 4, 5, and 7.
Well, this is in the event that they're
Oh,
all get
yes.
approved, that you're okay with all those conditions?
Oh, absolutely,
Okay, all
yes.
right, that's what I need to know. Thank you.
Thank you.
Okay. Any other questions for the applicant? Okay, we do have a public participation on this case, so after they spoke, I will give you an opportunity for a rebuttal, okay?
Thank you.
Okay, Mr. Richard McCloskey? Good morning, sir. If I could get your name and address for the record.
Yes, sir. Richard Malzowski, 369 Routh Avenue.
Okay, sir, you would like to comment on this case?
Yes. Well, the question is where will they put a septic system when they subdivide this property? Because they're all on septic, right? And the challenge we have in this neighborhood is, you probably heard in Ian, we all got pretty flooded out, right? So by subdividing this property, you're actually increasing the density of the houses in the area, right? So that's kind of a challenge for us as well. And I understand where the problems are probably with the permits, because the city was handling them for a while and then the county took them back, and probably our permits with the city for what was built there. Because that's the same way with my property too, when the city was handling and permitting it one time. So that's the concern we have, is just the density of the, because all the houses, lots there are a third of an acre or bigger. So,
You realize this is just for what is existing, correct, sir? And this,
yes, sir.
so it wouldn't increase it any further than what is already there.
Well, right now it's a single-family residence. When you subdivide the lot, it's going to be 2 single-family residences. That would increase the density of residences on that property.
Okay, and where do you live across the street? I see it's on Ruff Avenue there.
Yes, if you look out my front door, you'll see that compound.
Okay, and how long have you owned the property?
I've been there since 2016.
Okay, so all that was there when you purchased your property, correct?
That is correct.
Okay. All right.
We knew the lady that was there. It was a doctor that actually built the compound, and he had his family, different family members would come and stay with him, and they stayed in the big house.
Okay. Any questions for the speaker? All right, sir, thank you.
Thank you.
Do we have any other public participation forms? Okay. Let's get the applicant to come back forward, please. Any more comments you would like to make?
Only other than, as you mentioned earlier, these structures are to be in existent for quite some time. I still don't believe that it'll affect any of the neighboring properties that hasn't in 20 plus years, and I don't believe it will any further after this. Again, we're trying to get the property in compliance. This is unique in its nature. I've never really seen this many lots. I mean, the structure in this property, you know, but here we are. We're just trying to get in compliance. Thank you.
Okay. All right. We're gonna, Ms. Craig?
You mentioned that there were no complaints, and yet I see here the code complaint was emailed in from a previous tenant. Do we have any background on that?
Yeah, so that was a tenant, but what I was referring to, there was no complaints from from the neighbors over the years. There was never any issues. I think that it was a disgruntled tenant with the landlord, and they made the complaint. I believe that's as far as it went. There are no more tenants. All the properties are vacant. My client had intended potentially maybe to move into the 2-story structure, but isn't at this time due to everything that's been going on with the property.
Okay. Thank you.
Thank you.
If we don't have any other public participation, we're gonna close the floor and open up for commission discussion or a motion.
No discussion, I'll make a motion. Case V-24-005, make a motion that we approve all 7 variances with the 6 staff recommended conditions.
Second.
Okay, I've got a motion on the floor from Mr. Costa to approve variance V-24-055, variances 1, 2, 3, 4, 5, 6, and 7, with the 6 conditions from staff, and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, Ms. Shelley, could I have the next case, please?
Yes, sir. Case number V-24-056, variances to the minimum yard requirements on rural agriculture RA zoned property.
Thank you, Ms. Shelley. Ms. Ray, this one is yours.
Good morning again. The applicant is seeking variances for an existing ADU, accessory dwelling unit, to resolve a code violation. Variance 1 is to reduce the north side yard from 25 feet to 15.1 feet. Variance 2 is to reduce the west rear yard from 45 feet to 44.4 feet. In 2022, a building permit was applied for to construct the ADU. Final inspections were never completed, resulting in the permit being closed by the county. A code complaint was filed in February of 2024, and upon review, it was discovered that the ADU was built within the setbacks. Staff's recommendation for the two variances is for denial. However, should the PLDRC find that the applicant has provided competent substantial evidence to support the approval of the variances, two conditions were provided for consideration. I will also add that there was a one letter of opposition included with your staff report packet. I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? Is the applicant present? Good morning, Mr. Watts.
Good morning, members of the board. Mark Watts with the law firm of Cobb Cole, 231 North Woodland Boulevard, DeLand. I appreciate the opportunity to be here this morning. Although I will say this is one that my clients wish they weren't here for. Paul and Andrew Schaefer are here with me. They're the beneficiaries of the trust that owns the property. This is, I've got one slight correction I wanted to make in the staff report, and then wanted to stipulate that we are certainly okay with the staff conditions. I do have one tweak I'd ask to make to that, and I'll get into that in just a second. The correction that I'd like to just make is, in the staff report, it states that there were no final inspections conducted. And so I brought this morning the printout from Connect Live just to go through the inspections that were done with regard to the property. And I'll put this up on the overhead here in just a second. But there was an inspection done for the slab that the ADU is resting on, which is kind of where part of this issue came from. In August of 2022, there was a final structural framing inspection that passed in September of 2023, and then the building final inspection in December of 2023. So essentially, as the staff report otherwise indicates, this is a permit that was submitted in 2022 for an accessory dwelling unit. The accessory dwelling unit was located in the corner of the property, compliant with all of the required setbacks. During construction, the contractor that had been hired to do the work poured the initial slab. It was determined that they had poured the slab the wrong size. It was 10 feet short, basically for the area that was needed for the stairs to land. When they came back to pour that additional slab for that extra distance, they poured it on the north side of the slab they had previously poured versus the south side of the slab. And so that's what resulted in the ultimate encroachment into the setback. And I've got some pictures that'll show that as well. So based on that and a number of other issues, our clients took over the permit as owner builders. Get back to the timeline. So the permit was initially, again, applied for late 2022. Around June of 2023, our clients took over the permit. At that point in time, the structure had already been substantially erected. Hadn't had the final on the framing yet, but the final on the framing came about 2 months after they took over the overall building permit. They completed the building in December 2023, had that final inspection for the building by the county. It passed and was signed off on. You can see that on the screen above you. And then about 2 months later was when it was determined that the setback issue was existing. And there was two setback issues. There's one on the western property line that's about 6 inches, and then the 10-foot setback issue on the north. So just to let you know, or to give you an idea of what we're talking about, these are the pictures of the structure in question. So the setback issue relates to the stairs and the deck that are required to access the accessory unit. This is a second-story accessory unit. There's not another means of access to the accessory unit other than, the stairs that you see here. So if you look at the face of the building there itself, that complies with the setback. It's the stair structure to access the accessory unit that extends into the setback. If you look at the next picture, that's just another view of it. In the vegetation to the right here, about 15 feet from where those existing stairs are, there is a fence that is the property line for the property. Go to the next picture here. This just gives you an idea looking up on the deck itself. This is the only access point into the accessory unit. It's an access that goes into the combined living, dining, area of the accessory unit. The back portion of the accessory dwelling unit has a bedroom and a closet and a bathroom. So there's not another point at which we could reconstruct access into the accessory unit. And I think the last couple pictures there are just additional views that show, again, that's the additional slab that was added for the stairs and everything to be constructed on. And I think that's the last one you've got. Okay. And that's just showing on that where that extra slab was added after the initial slab was poured. So again, this is one where we really wish we weren't here. They had to take over this construction from a contractor that had created some other issues as well. They tried to do everything they could to comply with the code and follow the requirements to complete the construction, but found themselves in a situation where after construction they realized it had been put in the wrong location. And so that brings us here today. Now, I said in the beginning that we're good with the staff, recommended conditions if you choose to grant the variance. My one request would be the staff on condition number 2, that the applicant shall apply for and obtain after-the-fact permits within 30 days of the approval of the variance. We have absolutely no problem making that application. We don't control what happens from there with regard to the inspections being done and everything else. So that would be my only concern, is perhaps having 60 days instead of 30 days to make sure we get all the inspections completed. The other thing, we did review the letter that came in from the neighboring property owner. Absolutely agree, they're the ones that are most affected by that setback. And so we would suggest adding an additional condition that screening vegetation be planted along the property line adjacent to where that deck is located and that access is located, sufficient to make sure that they have vegetated screening from where the deck is located and where the structure is. So we'd be happy to stipulate that as an additional condition. Our clients have looked at something like clumping bamboo or something that would grow fast and provide a solid screen through there from a visual standpoint. So with that, happy to answer any questions you might have, and if there's anybody else here to speak to it, happy to come up and respond to any of their comments.
So you're actually requesting an additional condition to what is already there?
Actually requesting that, again, we read the letter from the neighboring property owner to the north, their concern about privacy and screening. We think that's a completely appropriate concern to have. We would be happy to add that stipulation of additional vegetation that has to be planted and maintained by the owner.
Okay. Mr. Costa, you had a question?
I do. Actually, two things. Can you put that Connect Live back up there on the screen, please? The reason I'm asking her to put that up there is because I saw something and I just want to point it out. I think you pointed it out, but I want to make certain, and I also asked staff, I need clarification here. I'm getting twisted two ways. So there at the very top, second line that you have highlighted. So the building final passed in December of 23.
That's correct.
So on your staff recommendations, one of them is to apply for an after-the-fact permit. Why would you do that if you've already passed the final?
Because the permit was subsequently canceled.
After it was finaled?
After it was finaled. There was never a final CO issued. So the building final inspection was passed in December of 23.
But they didn't issue a CO?
They didn't issue a CO. There was a well inspection that never was completed. And there was a blower inspection, I think, that was outstanding. There was a septic inspection that was actually listed as not completed, but we confirmed with the health department that was.
So that's why I find it interesting that if those were not completed, how did the building final get passed?
I'm not sure. But the inspection was done and it passed that
Okay.
inspection.
And so then back to staff, then when you're putting on here that.
I think you do have notes that the health department still had a couple of those outstanding issues with septic.
Right, which hence the final should never have passed. Should never have been granted and then rescinded.
The rescission was based on occupancy. Our clients felt that, because they had passed their final inspection, they actually moved one of their employees that works for them into the property. Paul Schaefer, or who's here with me, is moving into the property.
Sure.
It'll be owner occupied
Right.
in the main house. But since that hadn't occurred, the building department canceled the permit based on the fact that it wasn't owner occupied and they had somebody that was in leasing the ADU.
And I get that, and but the thing is that once you get that building final, you're expecting that the CO should be coming.
That was our
shortly.
client's understanding.
Mr. Chair, we do have the building official in the room if you have any questions for him.
Okay, Ms. Smith.
Thank you. So yeah, that was my point of contention, is if it was finalized, what happened here?
Yeah.
And it looks like it was withdrawn. So
It was ultimately withdrawn. That permit was revoked. We need to reapply for it with a contractor based on the request from the
okay.
the,
All right. And there's
building department.
no longer anybody living in the ADU currently.
There is nobody renting the ADU.
Renting
It's
the
still
ADU.
occupied. They're not paying rent.
Okay. All right. Thank you.
Any other questions for the applicant?
I have one question.
Ms. Shelley?
Yes, in the third paragraph in the letter, they were talking about an additional ADU?
If you look at the attachments to the letter, there is actually on page 21 of 29 of your staff report, there's a number. You can see the buildings that are on the property. So if you look at that blue rectangle, the top left corner is the ADU that we're talking about.
Correct.
The main house is just kind of below that.
Yes.
There's a shed and garage structures that are on the left side below that, and there's two structures that are off kind of to the right side. One of those is a workshop. The other one is going to be used as a craft room. They did initially start to build that one as an ADU back in 2020. They've never applied to use it as an ADU. It'll actually be used as a craft or shop room.
Perfect. Thank you.
Any other questions for the applicant? Okay, Mr. Watts, we do have a public participation form. I'll give you a chance for rebuttal after he's spoken. Okay, Mr. Orville Brannon?
Well, good morning.
Good morning, sir. Could I get your name and address for the record?
Okay, my name is Orville Brannon. I live at 2260 East Dale Circle. And at 81 years of age, this is the last place I want to be. I can tell you that. We have lived at this address for 43 years. We have a great neighborhood. It's been fantastic over the years. Everybody has done everything, complied with regulations issued by the county, done everything. The problem that we have had with this is that, and I know we're just addressing one issue here today. Believe me, I understand that. There are numerous zoning violations with this property. The county has issued all kinds of, I shall use the words, cease and desist orders. Nothing has been paid attention to. Everything is going ahead just as if there was no laws, no regulations, no nothing with this whole property. We're discussing a setback issue here today, but there are numerous violations on this that are, Ms. Hanners, who lives next door to this property, is here, and she has done a lot of research on this, but I don't think I would be too far out of line to say there are in excess of 10 or more violations, zoning violations currently going on with this property, and yet nothing is being done. They're being issued completion certificates, all kinds of things, but there's no way that it can possibly be, but it's happening, just as was brought up here. How could this have been signed off? We don't know, but it has been. There's things like that going on with this since the onset. Now, I don't have any idea what's happening. I'm certainly not an attorney, but I can just tell you that this does not fit with our neighborhood. There are structures built all over this property. And again, perception, our perception as neighbors that are all here today, supporting, our perception is that this is going to be a rental property, is what this is being built to do. For example, zoning clearly states that on a property like this, there can only be 2 electric meters. Well, there are 3 on this. There are 3. Now, what do you need that for? You obviously have other plans for this besides just living there. The auxiliary dwelling that we're referencing here has been occupied since January, and zoning requires, I think since January, maybe December, that says that for anybody to occupy an auxiliary dwelling, the main dwelling has to be occupied before the auxiliary can be. Nothing like that's been done, and there's been people living there right on, even after orders were issued for them to remove and not have anyone living there. They've gone right ahead. They haven't slowed down anything. Nothing has changed. Nothing has been done. We don't know what the deal is, how this can happen. Somebody's dropped the ball along the way. That's all I can say.
Okay,
And
Mr. Brandon.
That's it. That's my thing.
Okay, do we have any questions for the speaker? Okay, we do, thank you, sir.
Yes, sir.
We do have another request here from Ms. Hanners. Good morning. Could I get your name and address for the record, please?
Good morning. My name is Chastity Henners, and I reside with my family, my husband and children, at 2150 West Dale Circle, which is the property that is abutting where the ADU setback is. There's a lot of, like our other neighbor said, there is a lot of questions with this property on how things were permitted, how they were allowed, interpretation of definitions. And, you know, if you looked at the original picture in this property, there was a house and a structure that when the original owners had it, it was a one-bedroom house, which fit the definition now of an ADU. The craft room, which they're claiming it to be a craft room, in supporting documentation with the permit, it does have the electrical for one, I think it's a power electrical one, has that it's a dwelling with a kitchen with 2 occupants. The original floor plan listed with that craft room shows the layout of a bedroom, a living room, a bathroom, and it was updated, but all the supporting document with that permit was not updated. You have 2 accessory structures that are larger in square footage than the main property, the main house. That the 3,500 square foot metal building, the 65 by 65 carport, the house with the addition that was built on it is only like 3,200 and change. All 5 of these structures that they've built on that property are under owner builder permit. There is so many questions. I have been asking this county to do an investigation into this property on how the permits were issued, to come back with clarification, and every person I contact, I hit a roadblock and nobody has done anything. And now they're starting to have these violations. The setback issue, in this one in particular, the deck is the issue. How this was approved to have the entrance to that property face the neighboring lot and not the interior, I've questioned that. I can't get an answer. Now they have that deck there. The deck is what's in the setback. And the county did give them an option to put a 3.5-foot staircase, which even by the pictures could have been done by putting the door opening interior instead of exterior. And they would have remained in the ordinance, because I think that's a criteria. You can have a 3.5-foot staircase that goes over the ordinance. I'm not trying to be a pain, but this property has exploded into like a compound, which doesn't even look like any other property in our neighborhood. And the fear is, what is the intention of all these structures that could be livable spaces? Even the addition they put on the main house could be an additional rental. There's a bedroom, a living area, a bathroom. I don't know. I just could keep going on and on. I'm sorry.
Okay. Any questions for the speaker? Thank you, ma'am.
Thank you.
Okay, do we have anybody else that'd like to speak to this case? Okay. Mr. Watts, if you could come back forward, sir.
Yes, sir. Thank you. We are aware there's 2 code enforcement complaints or code enforcement open items. They're actually scheduled for the code board next week. They both relate to the ADU that's at issue this morning. I'm not aware of any other open code violations or anything else with respect to the rest of the structures on the property, all of which were properly permitted. You do have a shed structure that has actually pickleball courts on it. There's 2 courts that are underneath the kind of one of the pavilion type structure that's there behind the main house, and there is a garage. Those other 2 sheds and structures that were down to the bottom right of the main house are, again, accessory units. Our clients are very well aware that they are only entitled to have one that's used as an accessory dwelling unit, and that's the one that is at issue again this morning. Again, we're we can't do anything other than be here this morning to try and resolve the code enforcement issues with regard to the setbacks and the permitting issues. I think our clients certainly, don't have any intent to be anything other than good neighbors. They are using their property in a manner that's consistent with what they're allowed to do from the zoning standpoint. We just have an error that we're trying to correct.
Okay. This craft house that is being brought up this morning, that is this occupied at the moment?
It's not. It's not. That, again, I think the original intent was that they were going to build that as an accessory dwelling unit. They recognized that they didn't have the opportunity to have multiple accessory dwelling units on the property. So Mr. Schaefer, Paul Schaefer, who's here with me this morning, they will be residing in the main house, and his wife will be using that as a craft room and a kind of a hobby studio.
Okay. Mr. Costa, you had a question?
Yeah, before we dismiss the applicant here, I have two questions, one for staff and one for the building official. For staff, first off, looking at the page 19 of 29, if we can put that up there, please, where it's got the pictures before and after, 2022 and 2024. Who submitted those? Is that that's an internal? Those are internal pictures, or was that submitted with a complaint letter?
That was with the letter of opposition.
Letter of opposition. All right. So looking at this, at the two pictures side by side, my first question is, have they exceeded the maximum square footage allowed of total dwellings on this property? Maximum coverage?
No, I don't believe so.
Are
Let
they
me
close?
let me double.
Yeah, that's what I'm saying. As I'm looking at the amount of I don't know how many square feet we're talking about here. That was my first question. And then while you're looking at that, and the reason I'm asking, since the building official never comes down here for anything, but he's here today for some reason, so I'd like to hear what he has to say on this particular case. So if you've got a couple of minutes, so I'd like to hear his opinion on this.
Sure.
Good morning.
Good morning. Kerry Lusinger, Chief Building Official. I really don't have anything to say. I'm an interested observer of this case, but I'm available for questions.
All right, well, I got a question for you then. How, on that one particular shot that was on the screen, that they got a final in December, but then with multiple open items, how was that just an oversight? How did that occur?
No, we require the well and septic stuff to be approved by the health department before we issue CO. It does not keep us from doing the final building inspection.
Okay.
We approved the final building inspection actually in July, just recently.
Okay.
Excuse me, July of this year.
So that we complete. So they do have a final then.
Final building was approved just a few weeks ago.
Okay.
I'm not sure what Mr. Watts had, but there. I just had staff double check on that for me, and it was approved July 24th, 2024.
For the final, and they get their CO just recently?
Was not been issued.
Has not been issued.
Excuse me. As Mr. Watts indicated, that permit was revoked by me.
Right.
It had been applied for by a contractor, and then the owners took over the permit.
Okay.
As owner builder, what you're allowed to do, if it's a property on, a building on your property, and you do not rent or lease that property or sell that property within 12 months after completion of construction.
Gotcha.
They violated that exemption of the statute, and the property had been rented.
And that's why that was revoked.
That's why the permit was revoked,
There
and
we
now
go.
they're required to hire another contractor to complete the permit.
Got it.
We'll issue the CO.
And then they can then they continue to rent it out at that point.
Boy, they could.
Yes, I got you. All right. Now we see. Now we're talking technicalities here, and that's the issue at a case. All right.
Okay, I have a question here. The craft house that they keep on referring to, do they not have to have an affidavit if that was possibly an ADU prior to the ADU permitting?
I don't know about that. I'd have to defer to either zoning or other staff as far as an affidavit requirement. What I can tell you about that is I was in that home or in that building. There is no kitchen in there.
Okay.
It is an open living area. There is a bedroom, there is a bathroom, but it does not appear to me that it will be used as an ADU in its current configuration.
Okay. But it can't be used as living quarters either, correct?
That is my understanding, could be used as a craft room. And
Okay.
if it was living quarters, that'd be another ADU, which they're not allowed.
Right. Even with or without a kitchen.
Yeah, there are no kitchen facilities in that building.
Okay.
Got everything but. No kitchen.
Okay. Okay, so I get it. Okay. All right, any other questions for the building inspector? Okay, thank you, sir.
Sir.
Mr. Watts?
Yeah, and just to follow up on Mr. Lusinger's comments, we fully understand that what we need to do to go through and finalize the permitting. Going back to the Connect Live, we did have the building final, the septic and the well inspections were a couple of the open items. There was actually a septic inspection that was done in September of 2023 and that passed. It just, the wires were crossed and it didn't get fully entered into the system that way. We have confirmed that since then. The other two inspections, I think, have now been resolved. I think the only thing we're waiting for is the well final water testing. Right.
Okay.
But aside from that, again, we certainly wish we weren't here. It's an unfortunate set of circumstances. We recognize that Ms. Hanners in particular, as the neighbor to the north, has that setback is the thing that affects her property the most, and that's why we'd suggest adding that requirement that landscape screening be planted along that north property line to make sure that that access, staircase and deck doesn't intrude on her privacy.
Okay. My question is for staff. Obviously, we're not here to address any code violations, and we're just specifically for the staircase. And, but these concerns that the neighborhood has brought up, the speakers have brought up, is there any way that can be actually made sure that they stay within compliance?
I believe Mr. Watts indicated this is actually going before the code board next week, so those will be addressed at that time.
Right.
With regard to the ADU, I think with regards to the other structures, if there's anything, I know the question of an affidavit with regard to the other structure, we'd be happy to provide the affidavit and make sure that we cooperate with staff on any of the other structures with regard to the zoning, but they all have been properly permitted.
Okay. The other thing for staff, is there a condition that we need to add on this craft house?
The craft house is not part of the variance.
That's what I thought. Okay.
So it does not need any variance approval. It's within setbacks. If it is being used as an ADU, that is a separate code enforcement violation,
Yeah.
which they will have to address, either stop the use or do something.
Got it. That's what I thought.
And if it made the board comfortable, we would stipulate to a condition that there shall not be any other ADU on the property other than the one that the variance relates to. I think.
Well, it can't by law.
It can't by law anyway, but we're happy to provide an affidavit or a stipulation to that.
No, no. Usually when you have another dwelling on the property, either be vacated as a dwelling or removed before they allow a building permit.
Correct.
That's the only reason I asked this. Okay. All right, any other questions for the applicant? Ms. Craig?
I'm curious about this thing with the 3 electric meters.
As I understand it, I can bring Mr. Schaefer up to address it more specifically if I can't answer it to your satisfaction. There was insufficient power to provide power to there are already 2 meters. They had to get another service coming into the large garage building, which is the 3,500 square foot shop structure that's kind of on the bottom of that aerial picture that you saw. So they brought in additional service for that. I got the head nod that was the third service. That
Was
came
it
in.
permitted?
Everything with those was permitted.
Yeah, okay. All right. Any other questions for the applicant?
Just want to confirm a few things that you said. So it will be owner occupied.
Will be owner occupied. Paul Schaefer, who's in the gray shirt here, will be moving into the primary building. They've been waiting for a final certificate.
And the
of completion.
the intent of the ADU is to actually become a rental unit, per se.
They do have an employee that is in it now. They moved in January. The only
Okay.
reason they haven't moved out was because they don't have any other place to go, essentially.
And then the completion and the fact permits, those are being done with a licensed contractor, not owner builder.
Correct.
Is that
We'll
correct?
comply with what the building official has requested.
And
of
we're
us.
talking strictly about the staircase
That's correct.
in this particular case.
variance for the west wall of the building.
Mhm.
The building actually comes down 6 inches too close to that rear yard setback. So we've got those two, that 6 inch, basically a survey issue when they put the form boards in for the
Well,
slab.
I don't have a crystal ball, so I don't know how this vote's going to go, but all I can tell you this is if they come back here with asking for variances on any of these other structures that are out there, I don't think they're going to get a very favorable response from this panel.
Well understood.
All right, that's all I got.
Okay. Okay, we're going to close the floor for public participation, open up for commission discussion or a motion. I would like to say that what's before us today, for those of you in the audience here, is we're looking specifically at the setback issue as far as the staircase. The code violations obviously is not our department, fortunately for us, unfortunately for you. Okay? I'm assuming that the public can attend the code enforcement board meeting? Yeah, and that's what I would do, if you do have an issue with that. But what we're looking at specifically today is a staircase on the side of the building. And for us to put an undue burden on anyone for what we're looking at, and I'm assuming that, like Mr. Costa said, unfortunately, we're not looking at everything that you are. Okay, and we can't. We don't take that I don't take that in consideration. Okay, I'm just speaking for myself. So, I'll open up for any motion or any more discussion. Ms. Craig, you had something?
I understand what you're saying about the code violations being something that's not on our table, but I do have a problem with the fact that there have been these ongoing issues, and they seem to have just been not tended to in any fashion, and I really dislike the fact that we're caught in a corner of only being able to address one unit or one part of this whole thing. And it's just, my opinion is that it's a shame that these issues haven't been addressed sooner.
As Mr. Costa stated, I think we agree upon that, but do you hold them at bay for what we're looking at here today? We're looking at specifically the variances to the staircase, pretty much for a staircase and 6 inches on the building. So, I mean, unfortunately, it's not that's your decision, whichever way you want to vote on this.
Yep.
I mean, I'm not trying to sway you one way or the other. I'm just trying to tell you how I'm looking at it.
I'm prepared to make a motion.
Okay.
Jenny?
Yes.
I make a motion, case V-24-056, that we approve variances 1 and 2 with the 2 staff recommended conditions,
Do we want to include the other condition for?
which was,
The
We
vegetation.
need to have that stay. Mr. Paulo, do you want to take that for the other condition?
I believe Trish has the provision.
We would ask that on condition number 2, that the words "and obtain" be removed so that they would apply for the building permit. And do you want to go, well, if he applies for and we remove those words, we don't need to go 60 days.
it apply for and obtain?
Well, no, we want to strike the words "and obtain" because Mr. Watts is correct. Our system may take longer than that.
Got it.
30 days or even
All right,
60 days.
and I'll amend the motion that on staff recommended condition 2, it to read, applicant shall apply for and after the fact building permit within 30 days. Okay.
What about the vegetation thing? Does that get included?
Okay, that's what I'm asking, is the vegetation
That didn't come up.
to the, they've agreed to do it then for the basic property.
They agreed to do it if the neighbor was asking for it, but she didn't ask for that. And I'm looking at the aerials. It looks like there's pretty good sized tree line on the side of that,
Okay,
side of those staircases. I mean,
right.
Okay,
Leave as is.
Mm-hmm.
okay. Okay, so we're just changing condition 2
Mm-hmm.
to say 4,
Should say for and after the fact.
to apply for
And after the fact.
and after the fact, rather than and obtain. We're
Yes.
striking and obtain.
Correct.
Okay. Unfortunately, I've closed the floor, sir. No, sir, unfortunately not.
So I'm waiting for a second.
We gonna get a second on that?
Got a motion sitting
Oh,
there,
I'll second it.
just floating out there.
Yeah.
Second it?
Yeah, I second.
Okay.
Thank you.
I got a motion on the floor to approve variances 1 and 2 with the 2 staff recommended conditions, with item 2 striking and obtain. They just need to apply for the after-the-fact building permit within 30 days. Okay. And are we leaving that open, Mr. Soria? Because if they apply for it, they still have their variance. They at
Yes,
some
yes.
point, they
So
have to obtain it.
Well, they would have to obtain the building permit. So what you are doing is basically they would have the variance. Variances are good for a year. If they don't act on it, if, within that time frame, the variance expires and they have to come back before you.
Right.
So this just basically makes it so that it gives leeway for the building permit application to last more than 30 days, which it potentially could.
Yes.
So if they don't get that building permit application within a year or start to use the variance will expire.
I think that a second pass would
Okay,
not be
but the
very
way it's worded is it says they just
Mhm.
shall apply for it.
Mhm.
And it could be an open application for a period of time.
Well, the building permit has 180 days to, once you make application. If you don't, go through the process, I believe the building permit application will expire in 180 days.
Okay, I'd like to have in there at least obtain the permit within 180 days, not just apply for it. Because I can see a loophole here where if they applied for it, even if it didn't go through, they've applied for it, so now they have their variance.
Or just for the year,
That's sure. That's a condition that seems reasonable if the board wants to.
Because Mr.
amend.
Watts has said he would go with the 60 days on obtaining it, we'll give him 180 days. That should be more sufficient to get it. More, over and above just applying for it.
Mhm.
All right, so let me reread this again then on the motion, amendment to the motion on the staff recommendation number 2. So the applicant shall apply for an after-the-fact building permit within 30 days of issuance of the variance and obtain those permits within 180 days.
Got it. Second.
Got it.
Okay?
Yes.
That works.
Okay. And we had a second for Mr. Sixma on the amendment?
Yes.
Okay. We've got a motion on the floor to approve variances 1 and 2 with the two staff conditions and with the exception on condition 2 to strike the word and obtain and add the obtain at the end of the sentence to say 180 days.
Within 180 days, yep.
180 days, okay. Okay. Any other discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
No.
Okay, motion carries
5-1.
5-1 for Ms. Craig in an opposition.
Thank you for your time this morning.
Thank you.
Good luck.
Okay. Next case, Ms. Shelley.
Yes, sir. Case number V-24-058, variance to increase maximum dock area requirements on urban single-family residential R9 zoned property.
Okay, and this is Ms. This is Mr. Shams.
Hi, good morning. So the applicant is requesting one variance to our dock ordinance to increase the maximum dock area requirement from 750 square feet to 1,168 square feet. The variance is for an existing dock with 2 boat slips and unpermitted additions that expanded its area. The dock was originally permitted in 2006 with 2 boat slips, and it was 740 square feet, which was consistent with our requirement. The applicant purchased the home in 2021 and then constructed roofs over the boat slips in 2022, which resulted in its expansion. The applicant also installed 2 temporary floating docks for additional watercraft, which further increased the square footage. One has been removed, and one is being used until the proposed boat lift is complete in the north slip. The south boat slip has a boat lift, and the north does not yet have one. Construction was completed without applying for permits to the county, and the applicant was reported to code enforcement in April 2024. Code enforcement issued a violation for an oversized dock, and he came to planning for an after-the-fact variance. He must get the variance to apply for the after-the-fact building permit to come into compliance. Otherwise, he will need to remove a portion of the dock to reduce the size to 750 square feet. The applicant was also subject to the Florida Department of Environmental Protection, FDEP, and received a permit from them on August 1st, 2024. FDEP will require the applicant to remove a portion of the dock's terminal platform to equal 160 square feet. The applicant originally requested a variance of the county for 1,173, but the request was revised by staff to be consistent with the permit that was given. The county's environmental permitting team reviewed the application and will require an environmental impact assessment during the permitting phase because the site is located within the natural resource management area. He is working directly with the environmental permitting team. The applicant contacted his neighbors throughout the process and did receive 8 letters of support for the variance. However, staff recommends denial as the variances failed to meet 3 of the 5 criteria. Should PLDRC find evidence to approve, staff does recommend 5 conditions for approval, and they are included in your packet. I'm available for comment or question.
Any questions for the staff? Mr. Shams, was there a previous variance request on this property?
No, sir.
Okay. And were the permits pulled on this?
So he did permits with FDEP, and now he has to have after the fact permits, so the variance comes first.
He had an after-the-fact permit.
No, he needs to apply for one.
Okay,
So he's
got
doing
it.
the variance first.
So in
to
other
do
words,
that.
there was never a permit pulled on this?
Not for the additions. So for the original dock construction, there was one in 2006, but that did not include the coverings.
Okay. All right. Is the applicant present? Good morning, sir. Could I get your name and address for the record?
Dan Bellows, 813 Grunion Avenue, New Smyrna Beach.
Okay, you've heard the staff report. Is there anything you'd like to add to that?
So thank you for getting here. It's been a long haul. What is on the screen there is what was, I purchased the house just a couple years ago. So back in 2005, what's on the screen was permitted through the county, and there was a DEP permit. So in my way of going online and Googling and DEP allows roofs, and there's a whole exemption criteria to where you can do some work to your docks. So what is showing there, and I think it might be in your packet, I have a photo of back in 2006. Should I hand that? So what was on the screen is what was permitted, what was there, and that picture right there from 2006 is exactly what it looked like when I bought it just a couple years ago. I went out there and I put roofs over my boats, like everybody else has, on both sides of me, all the way down to JB's Fish Camp and all the way up the other way. So what I've come to learn, I didn't know all this stuff a couple months ago, but I know now. Unbelievably, DEP does not care about roofs or how big they are. They can be as big as they want as long as they're the size of your wet slip and your boat. But they care about the area you walk on. They only want it to be 160 square feet. The county does not count the dock going, the walkway out to the dock, but they do care about how big the roofs are. So there's two completely different codes. But the bottom line is, I guess there's 5 criteria, 2 I've met. The third, those piles that you see to the left, I put a roof on. The wet slip to the north, I put a roof on. So I used the existing permitted structure. In my eyes, and Mr. Sham's done a great job, everything's fine, but I do not believe I expanded the dock. If you have boats sitting in your slip, that's an area, and I put the roof over the 2 boats, and I used the existing structure. And I did not add any area to walk on, and I didn't, blow it out. I have removed, I got 4 grandkids and 3 adult kids, and, one wants a jet ski and one wants a pontoon boat for the grandkids, and, so I was trying to accommodate, if I don't make it nice, my kids don't come visit me. So, if you were to approve it, I have no problems at all with the conditions that the county's asking for. But my neighbors, I got 8. I went to 8. I think I'm only needed 5 or something. But I talked to everybody around me, and it was kind of funny. I mean, it's they all go, we can see it. We know what we're getting into. I mean, the roofs are on there.
Right.
So,
Basically, you just put a roof over the boat slip that was currently there
Existing
and
slips.
permitted it already for the boat slip.
The boat
from
slips were both
DEP.
permitted. What's on the screen right there was permitted by the county and DEP back in 2005 and finalized in 2006. Somewhere along the way, so the county's still happy with that, but somewhere along the way, DEP no longer likes all that walking area. They want it reduced to 160 square feet because I'm in an aquatic preserve.
Okay.
If I wasn't an aquatic preserve, if I was just a little bit further in either direction, I could be 1,000 square feet by DEP and be exempt. So in my permit that I now have, just got it a couple weeks ago, DEP has no problems with the roof and everything, but they want me to pull up some of the boards that you walk on, which I'm having to do.
Okay.
So it's a trade-off.
Got it.
Trying to keep the sun off my boat.
Okay. Mr. Shams, when you did the original permitting for the dock, was those pilings took into consideration? Because they do extend out of the water.
Yes, the pilings were part of the original permit.
So all he needs is a permit for the roof.
Yes.
So if they were part of the original permit, why are we asking for a variance?
Because the county's dock ordinance looks at anything under a roof counts for the square footage. So because he's adding roofs over both of them, it's expanding the area of the dock.
So in other words, where the dock where those pilings were when it was originally permitted was not considered as part of the square footage of his dock, even though the pilings were there.
Yes.
How does that work? Okay, never mind. Okay.
I'm confused here, so.
Yeah, me too.
You're saying it's the statement request is an unpermitted dock on
Your
page 1.
mic's not on.
On page 1, it's showing that you have unpermitted dock. That's on the summary request. But yet, the applicant's telling me he does have permits that have
So the
been,
dock is permitted, but the additions are not. I'll make that clarification.
it says unpermitted dock, so it should say unpermitted
Yeah.
Additions.
It was
roofs. Okay.
Yeah.
All right. Now we're cooking.
Mhm.
All right.
Okay. All right.
Thank you.
Any other questions for the applicant or staff?
I do. On your staff recommended conditions, first off, with the applicant, you're okay with these 5 conditions that are on here, the way they're written?
Yes, sir.
And my question,
Could you come to the mic, please?
you're okay with these 5 recommended conditions,
Yes, sir.
including number 4, which is removal of the temporary docks floating docks?
Sure.
And so my question for staff is, why is that a request or requirement?
Because we only permit 2 boat slips
Uh-huh.
for a dock ordinance. So with the temporary docks, he technically had 4. So we're just trying to make it compliant. And right now he has,
Even though they're temporary?
yes, because it increases the capacity for storage of boats.
Okay. And you're okay with that?
Yes, sir. You bring up an interesting point. So I do not have a lift, a hoist that can take my boat out of the water in the north slip. So
Mhm.
there's a float there that I drive the boat up on.
Mhm.
So I think technically this county probably doesn't care about that one. But the point he's making, and interestingly, the state actually agrees on this one.
Mhm.
They count my jet ski or my kid's jet ski as a vessel. The pontoon is a vessel, and then my other son has a 17-foot Key West. Anyways, you can't have 4 vessels. So the floating docks, they're saying, are providing additional
You got to
slips.
get rid of a few toys.
Gotta get, which I've already done.
Okay.
So, yes,
right.
I agree with.
Okay. All right. I
Mr.
would have fought
Chair.
for that one,
But
but
the floating
I
docks
would love
are-
to have another one. It's very, anyways.
Mr. Chair,
If you're within compliance in this DEP's requirement of no more than 4 vessels, you said, correct?
No. DEP, it isn't interesting. They only want me to have 2 vessels at this point.
Oh.
And that's where I think the county is, 2 vessels.
Got it.
So I have 2 slips, 2 boats. I've hauled I took the jet ski out and I took the other Key West out. So I only have 2 boats.
But you can have that floating dock underneath the roof, correct?
So
That's what he's talking about?
That is temporary until he constructs the boat lift.
Mhm.
So once he does that, he'll
Oh,
remove
until
the
he
temporary.
constructs the boat
Yes.
lift.
Then I will remove that one.
It's just there to hold his vessel at the moment.
Got it. Okay.
and then on number 5, since I've got you up here, that is the meat and potatoes there, where you still have to work with county environmental permitting. You're aware of that situation?
Yes, it does make me a little nervous, I will say.
I would say.
But I was to understand that they needed a biological company to do an EIA report, and I have done that. It has been submitted, and then the environmental department sent it in an updated letter that says they have no objection.
Okay.
I'm hoping that's the.
Okay, gotcha. That's the attachment we got this morning? Okay.
Isn't it part of the DEP
no,
permit?
that's going to be part of our wetland alteration permit. They need the EAI for the permitting process.
Which I've done.
But
So,
isn't that required through the DEP permit also?
They did
I'm not sure what's required from the DEP. I'm assuming he's got his DEP permit, squared away, but we're working within the county process. So if it's one and the same, sure, you can use the same report.
Well, that's what I'm saying. It's kind of redundant to require him to do both if he's already required to do it in the DEP permitting.
I'm not sure if they're the same or not.
so
EP did not require it, and they have issued my permit, which I have with me.
Okay.
Only the county asked for it, which I have gotten, and there was no environmental impact, and I'm not touching the water, and I'm not moving the piles.
so
Got it.
going back to staff, so number 5, since we have this letter of no objection from EP, can we strike 5 as a condition?
We would prefer that you leave 5 in. We did work with our environmental team. They did issue a different memo initially. They wanted to see an EIA on the front end. We asked them if they could handle that in the building permit phase so that we can bring our variance forward, because we do have shot clock requirements
Okay.
to move these through.
All right.
But I did, so I got the report, I provided the EIA, and then I have a letter from the environmental department accepting it and no longer having any objection, which is in you should
Right,
have.
It's in our packet.
Yep, okay.
So could that be removed?
Well, staff is requesting no.
There.
That leaves the door open for them to have other questions
I
for you.
know, that's.
Okay.
Mr. Chair, just one final thing. Staff is recommending that condition number 3 be from 30 days to 60 days, to go in line with, to make sure that we're not going to put the applicant in a position to violate the variance.
Well, I was going to make a change to the motion anyways. I wanted to keep it consistent with the previous one and basically say, I'll apply within 30 days and obtain within 180 at the end of the sentence. that stays in consistency with the previous case that we just addressed.
That's fine.
Okay.
All right.
I guess we have
160 days, you said?
180.
180. Got it. Okay. Okay, we're gonna see if we got any public participation for this case. Okay, so we don't, so we're gonna close the floor for public participation and open up for
All
commission
yours.
discussion or motion.
So I'm looking at multiple pages of, I have no objection to this, letters of approval, or I guess of support for this variance from the neighbors, and knowing the area and seeing what's down there, he's not out of the ordinary, out of the norm. Personally, I would have fought to keep my floating docks, but he's okay with removing them. So with that being said, I'm prepared to make a motion.
Okay, Mr. Costa?
Case V-24-058, I make a motion that we approve the variance with the 5 staff recommended conditions. And condition number 3, changed to read as follows: the applicant shall apply for all county required permits within 30 days of the variance approval and obtain them within 180 days.
Didn't you say 30 to 60?
No,
No.
apply within 30.
Good.
Yeah,
Okay,
they can
second.
apply for 30.
Apply within 30 and then obtain within 180.
Got it. Second.
Okay, I've got a motion on the floor for variance V-24-058 to approve variance, and with the staff recommended conditions 1 through 5, with the change in condition 3 to say the applicant shall apply for all county permits within 30 days and a variance approval, and receive the permit within 180 days.
Correct.
Yep.
Okay, any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Shelley, could I get the next case, please?
Yes, sir. Case number V-24-059, variance to reduce the minimum yard requirements on single-family residential R3 zoned property.
Can we read 59 and 60 together since they're tied?
No, sir, they're
No?
different
Two
properties,
separate?
different
Yeah.
things.
All right.
Ms. Smith, this is yours.
This is a variance to replace an in-ground swimming pool. It's an existing pool. The home is on John Anderson Avenue, adjacent to the Halifax River. A fiberglass pool was installed in 2000 when the waterfront setback was 10 feet. That setback was subsequently changed to 25 feet by the county. The applicant wants to replace the old pool with a concrete pool in the same location. So variance 1 will allow the new pool to be 13.9 feet from the seawall instead of the required 25 feet. And just note, this variance would not have been needed if we had the 10-foot setback in place. Variance 2 will address the north side yard setback of 4 feet. Instead of the existing curved pool on the north side, they're going to straighten it out and are now asking to be 4 feet from the property line. The minimum requirement for a pool is 8 feet from the water's edge to the property line. We do recommend approval of both variances, and we're happy to answer any questions you may have.
Thank you, Ms. Smith. Any questions for staff? Okay, is the applicant present? Can I get your name and address for the record, sir?
Eric Horeen, 1112 Feather Drive, Deltona, Florida.
Okay, you've heard the staff report. Anything you'd like to add to that?
I agree with the staff's recommendations and move for approval.
Okay. Any questions for the applicant? All right, do we have any public participation forms? Okay, sir, we're going to close the floor for public participation, open it up for commission discussion or motion.
I'll be glad to make a motion
Okay,
that we approve case number V-24059, variance to reduce the minimum yard requirements on single-family residential zoned property, subject to 2 staff conditions. Yep,
variances 1 and 2, correct?
correct.
Okay.
Second.
I got a motion on the floor to approve variance V-24059, variances 1 and 2 with the 2 staff conditions. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, Ms. Shelley, could I get the next case, please?
Yes, case number V-24-060, a variance to the maximum fence height on urban single-family residential R3 zoned property.
Thank you, Ms. Shelley. And Ms. Ray, this one's yours.
The applicant is seeking a variance to increase the maximum fence height from 3 feet to 6 feet in the south waterfront yard. The property is an atypical lot, which is a lot that abuts a street at one end and at the opposite end, and in this case abuts a water body. According to our code, fences shall not exceed 3 feet in height when erected on an atypical lot rearward of the rearmost point of the principal structure as defined by the required yard area. Staff's recommendation is for denial. There was a letter of support that was submitted from the adjacent neighbor to the south that would be most affected, and it was included in your staff report package. Should the PLDRC find that the applicant has provided competent substantial evidence to support the approval of the variance, there are 2 conditions provided for consideration. I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? The applicant present? Can I get your name and address again, sir?
Yes, Eric Horeen, 1112 Feather Drive, Deltona, Florida.
Okay, you've heard the staff report. Anything you'd like to add to that?
I do, and I have other things, but my design team did not show up today, so I would ask for the continuance if possible. Or, I mean, we can go through.
Okay.
You might as well go through the hearing. Everyone's here.
Yep.
So my recommendation is for the commission to discuss it. If you think there are any unanswered questions, you can continue it. Otherwise, you can vote on it.
Okay, we're going to go ahead and listen to your
Sure.
part, and then what we'll do, once we made our discussion, if we feel there's that we need more information, we'll probably approve, we'll listen to your request for a continuance, okay,
thank
sir?
you.
Okay.
The owner of the property would like to have more privacy because of the park dock that's 2 houses down, and they can see directly into his house in his backyard. Was going to have pictures and everything else for you today to show how they can see directly into it. And
What kind of a fence is it going to be?
it's a CMU block with stucco.
Okay.
And a decorative top. It will look really nice, and it
Okay.
won't be intrusive at all.
All right, sir. Mr. Costa?
Yeah, so you've got a letter of support from the neighbor who actually says, hey, I really would like to have that fence between the 2 of us, so.
Yes.
And he would be the one who'd be most affected from a view standpoint. So, that being said, I don't have an issue. Is there an existing fence now, and that you're just extending one, or it's an entirely new fence?
There is an existing chain link fence.
And you're replacing it with the wall all the way down from one end of the property to the other, or just in that one section?
Just 20, or just to the house.
Just that 25-foot section right there. Okay. All right, that's all I got. Yeah.
And Mr. Chair, on page 11, you can see the public dock that the applicant was referencing. So it's 2 houses down.
So that's the one in the center there by itself that doesn't stick out as far into the water?
Yes.
Yeah, that's what I figured.
Okay. All right. Well, we're going to go ahead and move forward with this.
Okay.
And then I'll give you an opportunity. Well, no, I'm going to close the floor.
Yeah.
No, we're going to go ahead and move forward.
All right.
Yeah, we're going to move this forward now.
All right, sir. Do we have any public participation forms? Okay, we're going to close the floor for public participation. I'm going to open up for commission discussion or a motion.
I'll be glad to make a motion
Okay?
that we approve case number V-24060, variance for a 6-foot privacy wall in the waterfront yard, subject to 2 staff conditions on page 4.
6. That's it, 4 or 6?
It doesn't matter.
Back up, sorry. Yep.
Okay, I've got a motion on the floor from Ms. Shelley to approve variance V-24060 with the 2 staff recommended conditions and a second for Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. All right. Okay, Ms. Shelley, can I get the next case, please?
Yes. Case number S-24-009, a special exception for a communication tower exceeding 70 feet in height on prime agriculture A1 zoned property.
Yeah, we can do this special exception in the and go ahead and read the variance in also, please.
Yes, sir. Case number V-24-057, variances to the minimum yard requirements on prime agriculture A1 zoned property.
And Ms. Ray, this one's yours.
Yes, sir. The applicant is seeking a special exception for a 180-foot communication tower on an approximate 1 acre parcel. The parcel is surrounded by the Lake George State Forest. It is owned by Clay Electric Cooperative, and they are intended to be the only user. There is an existing utility compound with a communication pole that has been in place since 1976. The proposed tower is to replace the existing. Clay Electric has recently upgraded their voice communication system, and the tower will provide expanded and improved coverage. It will also ensure that reliability and resiliency of critical infrastructure systems are met. The proposed tower is approximately 0.85 miles away from any residential dwellings. It's proposed to have a galvanized steel color to help reduce visual obtrusiveness. There is an existing gravel drive from South County Road 3. Excuse me. Due to the size of the parcel, a variance to the north property line setback is being requested. The tower is unlikely to be a hazard, as we have received an engineered letter stating that if the tower were to collapse, it would essentially fold over onto itself. For the special exception, staff's recommendation is to forward to County Council for final action with a recommendation of approval, subject to 4 staff conditions. For the variance, it is, like I previously stated, a variance to the north property line from 90 feet to 20 feet. For a special exception for communication towers, the setback must meet the distance equal to 1/2 of the height of the communication tower, with the proposed tower being 180 feet. The setback would be 90 feet. The applicant did state in their written petition that the proposed location of the tower is limited by the existing overhead transmission lines. This is the minimum variance to allow the applicant to construct the proposed communications tower. And staff's recommendation for the variance is also for approval. I'm available for questions.
I have a question. On 24-057, the variance, I believe you said 4, but I only have 2 staff recommendations for
There's 4 staff
057.
conditions for the
The
special
next one.
exception.
Yeah, the next one.
For the variance, there is only, I believe,
There's 2.
2, yeah.
On 50, okay, just clarifying that.
Okay, any other questions for staff? Mr. Costa?
We're just replacing an existing tower, is that correct?
Correct. Yes, sir.
Same height,
It's not the same height. The existing tower is a little bit shorter.
is shorter than this one?
Correct.
Okay. And this is for private communications or public communications?
The applicant is present. They'll be able to speak more
Okay,
on it.
all right, thank you.
Any other questions for staff?
I'm sorry, you said a little bit shorter. Didn't I see 100 to 180 feet?
Correct. It is. Sorry.
Okay. Good morning, sir.
Good
Get your
morning.
name and address for the record.
I'm Joe Johnson with Clay Electric Cooperative. The address of the property is 2111 Southwest County Road 3.
Okay. And you've heard the staff report. Anything you'd like to add to it?
I think there was clarification. There was a question.
Yes.
There's a question on the
All I can
height.
say is that this is for, this communication is for SCADA, which is supervisor control. So it's control and data acquisition to the sites in the area on the southeast side of Clay Electric's service area. So to provide coverage into that area. The current pole does not provide clear coverage. It's spotty because of the height and the pine trees, the attenuation, all those kind of things. So we're trying to get higher to provide resilient communication to that area.
Okay.
And it also is a relay point to a further place even easter in the Spring Garden area in East Volusia County as well.
And to clarify, this is to collect data within the area of the Clay utility?
It's
Is
to
that what it
collect
is?
information from that site and get that back to our control center.
Right. Okay.
So it's purely private communication, just intercompany
It's
information.
intercompany communication
Got it.
for Clay Electric.
Okay.
That's correct.
So no public benefit, really?
No.
All right.
And we're increasing the tower height by how much?
Well, I would take exception to the public benefit, yes. Clay Electric is there for the public benefit. Yes, sir. I'm sorry.
How much higher is this tower?
This tower, the existing tower that's on the site is, and this is a monopole, so it's not a tower, a big tower, it's a monopole, it's a single pole structure. The existing tower is 100 foot, and this would be 180 foot.
Okay. And I don't know, it's on County Road 3. We don't have an airport, the Pearson Airport within that area, do we?
No, but it's in the bombing range overlay.
Yeah, the bombing range.
We have filed with the FAA. We have our consultant here as well that filed. So we filed with the FAA, and we have clearance from the FAA for that site.
Okay, I guess this question would be more for staff than it would be for you. Have we notified our folks up at the bombing range on this?
Yes,
tower?
sir. I did reach out to the our Navy representative, and he had no objection to the proposed tower.
Okay.
Got it. Okay, that's all I needed to know there. Okay. All right, any other questions for? Yeah.
They said if not, they just blow it up, so.
Yeah, I just don't want one of their jets running into it after they leave Lake George. Okay. All right. Any other questions for the applicant? Okay, do we have any public participation forums? All right, we're going to close the floor for public participation and open up for commission discussion on a motion. Does anybody want to discuss the variance on this?
No,
No.
this is a public service item.
Okay, all right,
I'm prepared to make a motion, Mr. Chair.
okay.
All right, let's do this separately here. Case S-24-009. Make a motion that we forward the special exemption, case number S-24-009 to the county council for a final action with a recommendation of approval, subject to the staff recommended conditions.
Second.
Okay, I got a motion on the floor for Mr. Costa to forward the special exception case number S-24-009 to the county council for final action with recommendation of approval, subject to the staff recommended conditions of, there are 4 of those, and a second from Ms. Shelley. Any discussion on the motion? Hearing none, all those in favor signal by saying aye.
Aye.
Any opposed? Motion carries unanimously.
Mr. Chair, I'm prepared to make a motion on the next case.
Okay,
Case number V-24-057. Make a motion to approve the variance request with the 2 staff recommended conditions.
Second.
got a motion on the floor from Mr. Costa to approve variance V-24057 with the 2 staff recommended conditions, and a second from Ms. Shelley. Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, Ms. Shelley, could I get the next case, please?
Yes, sir. Case number Z-24-011, rezoning from prime agriculture A1 zoned classification to rural agriculture A2 zoning classification.
Ms. Ray, this one's yours.
So the applicant is requesting to rezone a 10.51 acre parcel from prime agriculture to rural agriculture. The intent is to subdivide the property. The subject property is currently developed with a mobile home on the northern portion of the property, and on the southern portion is used for pasture. The property is divided by Duroc Drive, separating the northern and the southern portions. The surrounding area is primarily A1. The properties are used for agricultural, single-family residence, and mobile homes. Surrounding lot sizes do vary from 5 acres to 20 acres. Multiple properties to the south along Ranch Road have recently been rezoned from A1 to A2. The existing future land use is rural. The A2 is assumed compatible based on our comprehensive plan future land use matrix. Rural was allocated for this area, suggesting that the land could be developed at a maximum density of one dwelling unit per 5 acres and provide a transition between agricultural uses and urban uses. The applicant has received 4 letters of support from the adjacent neighbors, and it is included in your staff report package. Staff's recommendation is to forward the rezoning to County Council for final action with a recommendation of approval. I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? Maximum allowable separation on the A2 is what, 5 acres?
Yes, sir.
Okay, and that's what our future land use is in? Okay.
Yes, sir.
Got it. Okay. Any other questions for staff? Okay, is the applicant present? Good morning. Could I get your name and address for the record?
Fiona Ash, 840 Pineda, Lake Helen.
Okay, you've heard the staff report. Anything you'd like to add to that?
No, the only thing I would add is if you look at the property to the south, I own that as well. We own all of it. It's a combined total of 25 and a half. My sister and I own the 10 acres we're speaking of. The county forced us in 2016, we bought the property to subdivide in order for my sister to have a home, which is on the north top corner. The south that we're separating is already my pasture, and it has been fenced in by the previous owner for 41 years. So my sister in the top right corner has been fenced in, her 5 acres for 41 years, and mine, all combined, has been fenced in for 41 years. So the only thing we're doing is just making it so my 5 is attached to my 15 and her 5 is her 5. So this won't change any future land use. It's already a pasture. It's been a pasture for 41 years. I use it as a pasture, and that's how it's going to stay.
Okay. Okay, any questions for the applicant? You have any? No. Okay. All right, we do have one participation form, and I'll let you have a chance for rebuttal after they have spoken. Okay, Mr. Montgomery. Good morning, sir. Could I get your name and address for the record?
Randy Montgomery, 1480 Duroc Drive.
Okay, you've heard you'd like to speak to this case this morning?
Yes, I've owned 5 acres directly across from it for 41 years. And by my understandings of the letter, they were going to put another home in there. If it's going to be intended and stay a pasture, I have no issues with it. But if it does become A2 and it allows a 750 square foot trailer, then it pretty much an eyesore. This property is also, all the roads are maintained by property owners. It is not a county maintained road, and there are only approximately 4 people that even do anything to the road as far as upkeep or improvements for materials. This place has been subdivided quite a few times, and we have over doubled the amount of people that are living out there. And there's very in consideration of the dirt roads from some of the residents that just fly up and down the dirt roads through the mud puddles, slinging dirt and water 40 feet out from the road, and nobody seems to care about the roads or help maintain, or even if they don't help, they contribute to.
Okay. This rezoning puts it more in consistency with what you have there of your 5 acres.
Yes.
So it shouldn't be of any different than what you currently have there. And as far as the development, obviously I understand where you are on the development side, but we're looking at just the zoning of it right now.
Correct.
So-
But that's also when I purchased this property,
Mhm.
it was already pre-subdivided and there was no other property available.
Mhm.
So I was limited to the 5 acres.
Right.
Since then, I believe it was 85, it was designated that it would be 10 acres or more to be buildable. And I even went through a cost when I just built my new house on said property that I had to show that I did not own any adjacent property at any given time, or I couldn't build my new house.
Mhm. Okay. Any questions for the speaker? Okay, thank you, sir.
Thank you.
Do we have any other public participation forms for this case? Okay, I'll give the applicant an opportunity to have a rebuttal, if you'd like.
As for the road, he is correct, except myself and my husband are, and him are the only ones that maintain the road. So we actually take care of the neighborhood. As for him having the 5 acres, he is correct, and we attempted to keep my property from being subdivided in 2016, and the county forced us to. So in reality, I mean, it's still same family, same thing, and the 5 acres that he can see already has my cows in it, and none of that is ever going to change. So that's it.
Okay. All right. We're going to close the floor for public participation and open up for commission discussion or a motion.
So I want to make sure I'm clear on this. We're subdividing this parcel into, and it's actually, we haven't closed the floor, or is it still open?
We've closed the
Oh,
floor.
have we? Okay.
Oh, do you want to?
I'd like to ask her a question, yeah.
Open it back up if you have a
Please.
question
Yeah,
for
I
the
do.
applicant.
So the intent here is to basically take this property and split it in two, so that you can attach half of it to your sister's property and half of it to your property. Is that correct?
No. If you look at the L shape, the
Yeah.
top right is my sister, and it's completely fenced in, and you see Durock comes through and loops down in between what
Uh-huh.
we're trying to separate. That loop on the right is her gate, the loop on the left is my gate, okay? And so we're not subdividing my sister's, we're separating right where that loop is directly in half, and I will have it reattached to my property that I own to the south. Do you see what I mean? So Durock splits the two.
It's just adding on, it's taking her 5 acres and attaching it to her existing property.
Yes.
The 5 acres that we're splitting off of this one. So there's,
Yeah.
so this is 10-acre parcel.
Right.
Has a house on it that your sister lives in. And so by cutting it in half, it remains hers at 5,
Mhm.
and then the extra 5 is going to your side.
Which, yes.
Gotcha.
That
All
is
right.
all fenced in to my south.
Are
at the
you
15
planning on doing a
acres.
lot combination at that point, or are you going to leave it as 2 separate lots?
We'll probably leave it as 2 separate. The only reason, and not for, anything to build, the county forced us to do this, and we've already spent thousands of dollars multiple times to get to where I am today, to redo the whole process all over again.
Got it.
So for me to reattach it, I would have to go all through zoning again, put it back to A1, have to see all of you guys again, and again, pay $3,000.
We're a really friendly bunch, by the way.
You guys are amazing. No, you guys are awesome. It's not been you guys. You guys have been awesome. So I would love to reattach it. However, this process that I started in 2016, that I have already paid upwards of $12,000 to get to where I am today, I would have to pay an additional $3,000. See you guys again. I'd love to see you again, but that's kind of where I stand.
I'm sorry that it's cost you that much to get this far.
It's
but-
just
Okay.
left and right handed.
All right, I'm clear. Now I'm clear on what's going on here. Thank you.
Okay. Any other discussion on this case?
I'm ready to make a motion.
Go ahead.
KC 24011, I'm gonna make a motion for approval to be forwarded to county council.
Second.
Okay, I got a motion from Mr. Sixsmith to forward the rezoning application case number Z24011 to the county council for final action with recommendation of approval, and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, Ms. Shelley, could I get the next case, please?
Case number CPA-24-003, small-scale comprehensive plan amendment from the urban low-intensity ULI future land use designation to the urban medium-intensity UMI future land use designation.
Okay, let's go ahead and read in the PUD also, so we
Yes.
can address both of them.
Yes. Case number PUD-24-003, a rezoning from the urban single-family residential R3 zoning classification to a planned unit development with residential subclassification.
Okay, thank you, Ms. Shelley. Mr. Shams, this one's yours.
Hi, good morning. So I'll go through the CPA first and then the PUD.
Okay.
So the applicant's proposing a future land use change from ULI to UMI to develop the site with 48 multifamily residential units. This will be accomplished with the accompanying PUD. The site is currently undeveloped and vegetated as it was previously utilized as a commercial fernery. Remnants of the irrigation system piping and shade cloth remain on site. The surrounding lands are primarily residential, as the areas west, southwest, and south of the site are developed with single-family residential uses. The lands east and north are developed with commercial uses on lots that range between 2 to 3 acres. These uses include a medical clinic, a house of worship, and a commercial strip mall. With the current designations, the site could be developed with 24 units, as ULI permits density up to 4 units an acre. The request of 48 exceeds this allocation. So if the future land use change was approved, the maximum yield is 48 units. The site is within the City of DeLand's utility service area, and the city has indicated they have capacity for central utilities, both water and sewer. In addition, the site is subject to their 2050 vision plan, and according to the plan, the site is within the urban core, and the city has targeted it for higher intensity growth. We did send this application to the city, and they reviewed both packages. The city requested a sidewalk from the site to Spring Garden Avenue along West Beresford Road, and connectivity between the internal sidewalk network and the potential sidewalk extension. This will be determined during the land development phase after this planning phase. Overall, staff found it consistent with the comprehensive plan policies related to discouraging urban sprawl and meeting concurrency requirements. The applicant did submit a traffic analysis, and the site's existing designations could yield 271 daily trips, and the proposed change would yield 514. Volusia County Traffic Engineering did review this application and did not express concern that additional trips will not change the level of service on West Beresford Road. So overall, staff recommends forward to the County Council with a recommendation of approval. Now I'll go through the PUD itself. So they are rezoning from R3 to PUD for 48 multifamily units. The applicant previously requested to develop the site with 24 multifamily units and 5 single-family units. However, they held a neighborhood meeting in May of this year and changed the application to multifamily only. And that was due to citizen concern. The site acts as a transition because it's surrounded by more intense commercial uses along the northern and eastern boundaries and less intense single-family uses along the western and southern boundaries. And you can see the site is very close to State Road 15A, which is a county thoroughfare. It's approximately 225 feet west of this road. Thoroughfare roads are typically developed as commercial corridors, and it is sensible to locate multifamily residential uses in close proximity. The PUD itself will be developed in 2 phases. Each phase will include 2 multifamily buildings with a maximum of 12 units in each building. So each phase would be 24 units maximum. The first phase is estimated to commence in 2027 and the second phase in 2029. There will be a 20-foot landscape buffer along the southern and western boundaries and a 25-foot landscape buffer along the northern and eastern boundaries. This is consistent with our zoning code requirements. The maximum building height is 45 feet, which is consistent with the R7 zoning class. So we did try to mimic our existing standards in the DA wherever possible. The project does meet our PUD requirements and will dedicate 20% or approximately 1.2 acres as common open space. The applicant has said that they will utilize amenity areas, walking trails, and open grass areas as common open space, and this is visible on the site plan on the screen. So the current zoning in regards to traffic could generate 271 daily trips, but the applicant did a specific analysis based on multifamily uses, and the proposed PUD could generate 383 daily trips. So if approved, the rezoning would result in an increase of 112 daily trips. And again, traffic engineering reviewed this and did not express concern. So overall, staff recommends forwarding to the county council with a recommendation of approval. And I'm available for comment or question.
Okay, any questions for staff?
On the R3 zoning that they're coming from, that was strictly single family?
Yes, sir.
How many acres or units per acre on that? I mean, how many acres minimum for R3?
R3, I believe, is 10,000 square foot per lot.
Per lot?
Yes.
All right, thank you.
Okay, my question is more for Mr. Soria. On this City of DeLand 2050 plan, did the county have any input on this?
No, well, it's a vision statement from
Right.
the land. I believe we did make some comments, or at least growth management staff did. I was not involved because it's legally it means nothing to me. So I don't know if Trish, you were involved when discussing with the land about their 2050 vision.
We were, and it was suggested that every time we review projects near the DeLand area that will likely go into DeLand, that we address this plan so that we're all planning similarly.
I understand that, but here's what I have an issue with, is that we have no representation in the in the unincorporated area and the city decisions on their plans. And so we're having to look at our zoning and our future land use in relationship to their Vision 2050. And I'm not saying we have to, but we're having to take that into consideration. And so I don't know why we're even considering that when we look at these, is it in the unincorporated area?
Overall, you don't have to. This is a legislative decision by this body. So you are making a determination of, how and when in the future this particular parcel should look like. You can take into account all types of information, and one of the more pertinent informations is the city of DeLand, their proposed growth boundaries, and also their vision of the future. Because right now you have two competing policy decisions of what this particular parcel in the surrounding area should look like, both in the near future and the far future. But ultimately, it's a legislative decision by county council.
Okay. The other thing is this traffic review. When they do the review, what do they take into consideration? Because that outlet right there on Beresford Road and 15A is almost impossible to make a left-hand turn during the mornings or afternoons when the traffic is heavy on 15A, and they're going to add additional outlet there for higher in density if we were to approve this. How do they make that determination whether it's it's okay or not? I know we don't have anybody here from traffic, but obviously I'd like to know how they consider this.
So I would obviously defer to them, but I can briefly touch on it. They look at the level of service of the road, because the roads and a radius of this site have capacities, and based on the trips generated by the proposed development, they don't exceed what's allowable and go into a lower level of service. But
they look just specifically at the road itself, not necessarily where it comes out right there.
I mean, they do look at turning movements as well, but I would defer to traffic engineering.
Right.
Along that line, did they assume one vehicle per residence, or do they take into consideration that most people have two vehicles nowadays?
As far as how the analysis is performed, we do have the applicant available, and they can go into their traffic study a little more.
Okay. And Ms. Tucker, can you put back up the future land use? The proposed and what is there now? And on this future land use, we're looking at the, proposing that is this what I'm wanting? Okay. Oh, right here on the proposed, that ULI we have right there across the street, are we not creating an enclave with that future land use by doing this with the ULI? Are we not creating a ULI enclave?
There's not really a thing called spot planning. It's if there is a thing on, you shouldn't create spot zoning scenarios where you have a wildly incompatible use completely surrounded by other incompatible uses. Here, your determination is based off of density and intensity and adjacency to 15A and that kind of commercial corridor. So it's really, it's not you're not prohibited from doing this. All of this is within the county, so you're not really creating an enclave. It's just making a determination of the appropriate densities within the surrounding area, adjacency to, the state road and adjacency to this commercial corridor. So, I mean, that's a lot of discretion provided to this commission on whether or not they want to increase the potential residential density on this parcel, whether it makes sense right now and whether it makes sense in the future.
Well, one of the things that, what we're looking at, and there's some discussion on, is creating some of these, let's say the city were to annex in this development here, and let's say they annexed into that south portion there of the UMI there. There's some discussion of the people in the unincorporated area on these small enclaves, as I call them, of unincorporated area, is to turn them over and more or less go into the city, even if they don't want to be. Now this is the discussion going on, and I just don't want to create something where people in the unincorporated that are being, when we create enclaves, as we're doing here with the ULI, them having to be forced into becoming into the city of the land.
Most annexations are voluntary, and I say that in quotes because it's most likely this is within the DeLand service area. So, I don't know if DeLand does it, but most of the municipal water and sewer providers basically have it, if you are adjacent to, the city limits, that water, because they're providing water and sewer, they'll basically ask you to annex in, to have that continuity of service. But we do not allow the annexation of a random piece of parcel that's not contiguous or adjacent or compact to the city limits.
Absolutely.
So that's not allowed by law unless, the county and the city of DeLand enters into an interlocal service boundary agreement, in which case, we can plan for future annexations, but we do not have that with the city in this particular area.
But there is some discussion on these smaller enclaves, the smaller acreages of being
well, it's
I know
usually
it's
to
not
get,
there yet, but there is some discussion. I've heard it.
if there's
on
an
the council
enclave,
level.
as in you have an unincorporated area completely surrounded by one city, the policy, our policy and the state policy is to eliminate the enclave and to put that parcel into a municipality.
That's right, and that's why my concern is creating an enclave here on that piece of ULI there. In the bit.
We
Because-
wouldn't be, because that's, you can see the city of DeLand, that's a few parcels up. So, they would have to encroach pretty far. And we do an analysis of how is the city expanding? Are they doing so in a compact or contiguous manner? They can't, create a finger of incorporated municipality to kind of like tentacle or tendril their way to a larger piece of land, we object to that type of thing. So, when we review those city annexations, we review them for, is this the natural growth of a city, or are they forcing something unnatural to try to get to an area by, creating a corridor? So, in the event that does get annexed, we would look at, is the surrounding area also being annexed such that you're creating a compact and contiguous municipal area, not just, a long corridor of incorporated to land that suddenly balloons out into a large developed parcel.
Okay. I'll leave my rest of the comments for after they've had their presentation here this morning, so. Okay, thank you. Any other questions for staff? Okay, is the applicant present? Good morning. Could I get your name and address for the record?
Of course. Good morning. Jessica Gow at Cobb Cole Law Firm, 1 Daytona Boulevard in Daytona Beach, Florida. And we have a PowerPoint here that Kelly's going to help me with. And then the famous last words of a lawyer, it will be a brief one, and then we will go through any questions or comments. So this is the site, like Stephen said, it is located right off of State Road 15A. This started with Nika in our office, and I am just bringing it through here to the finish line. It is come a long way, I think, from the initial submittal, and so that's part of what we want to go through. And so the first slide here just goes over the proposed land use and zoning. You went over this with staff and in the staff report. I think the key item here and the planning behind this project is that you've got a commercial corridor along State Road 15A. We talked about that house of worship and the medical office here in the strip center, but kind of all along this road, our favorite, storage centers are popping up all over the place. And in terms of planning, we're looking at creating a transitional boundary between heavy commercial to those existing single family. And so the transitional housing types, multifamily townhome, putting in that transitional buffer between the commercial uses and the proposed residential is what you'll see here. So this was the original lot layout that Stephen referenced. You can see there are 4 buildings here for 24 units that were proposed, and then 5 single family homes along the rear portion of the site to kind of create, again, that step down transition. There were 2 voluntary neighborhood meetings on April 2nd and May 16th. And so April 2nd, we brought forward this plan, and the resident feedback was really they wanted to preserve the natural area and open space on the rear of the site where it abuts those single family homes, and asked if we could shift the plan to accommodate that. And the open space and the retention areas were kind of their key concerns. We brought back the revised concept on the May 16th meeting, and talked that through with the residents, and pending any speaker forms, I think we really went through a lot of their questions and concerns during those meetings. This is the current layout, and we'll show you a color version eventually, but you can see there are 4 buildings clustered on the front. What we want to point out, and we'll get into more detail later, is that we've swapped the retention areas to the rear of the site to create that buffering between the residents. Along the perimeter, you have the perimeter buffer, but anywhere you see a crosshatch is natural preserve areas. And so those will be areas that will remain untouched. We worked with the residents to discuss those. And all throughout here, we have some really cool low impact development principles that we'll touch on a little bit further. And by further, I mean right now. So as you guys know, the county has gone through how we incentivize low impact development within projects. The good news is that this developer has always committed to low impact design principles. They have a development called the Oaks in DeLand that has the similar principles pulled in. On this site, and we'll go back to the plan so you can see them again, there are 5 key low impact development standards that we've pulled in. They are on the plan, and so they're binding in terms of the concept layout. It's the use of pervious parking through the pavers to reduce the impervious footprint, allow additional drainage. There's subsurface retention and infiltration below the driveways within the area to reduce the clearing of land to meet retention needs. The natural vegetation in the landscape buffers allows for treatment and nutrient uptake. Bioretention and rain garden planting techniques are going to be utilized where those buffers are planted as we go through site design, and then a lot of the tree preservation with that open space that we can point out. We did have a question on the DeLand's 2050 vision plan. This is the snippet of the vision plan that applies to this site. We're in the blue circle, just the general area. And so the urban core category is the orange, and the planned commercial node is shown in that little red asterisk, which talks about the higher density of housing, as was in the staff report. I think DeLand's input into this area ties into them being the service provider for utilities, and so they have planned their facilities to accommodate a certain level of growth in these areas, whether they're incorporated or not, because they will be responsible for the water and sewer demands in that capacity in their plants. And like staff said, they did review and provide design comments. And then this slide, I think, Kelly, if we can swap to the other one, we have taken this and just colorized it to show green space and the different layout there, which I think will be more helpful. And when I converted it to a PDF to send to Kelly, my highlights went away. So we brought it back this morning. No problem. Perfect. I went a little crazy with the PowerPoint's highlight options. And so what I did was just highlight the retention areas. They're blue. That doesn't necessarily mean they're wet retention. The green, there are 3 different greens, although it's hard to tell. The core open space is just in that bright, vibrant green. Natural vegetation areas and that crosshatch is in another. And the planted landscape buffers are in that lighter green. So you can see the open space with this configuration is pretty substantial. And so as we go through just kind of as a county and how we plan and how we want to grow, I think this project highlights putting residential density where it makes sense in terms of where utilities are available. It's not urban sprawl. You have the buffers from the residents. You're using low impact development techniques, which the county is working now on drafts to implement and incentivize low impact development techniques in development, which would include density bonuses similar to what we're asking for here, to cluster that development, allow for that open space and stormwater retention and treatment on site, and allow the projects to move forward. And so with that, we do have our engineer here, and we're here to answer any questions.
Any questions for the applicant?
Yeah, I do. Building height, you said was what?
It's 45, the same as the
45,
existing.
how many stories would that be?
3 stories.
3 stories,
Mhm.
okay, all right.
And you referred to it as single family. It's actually a rental property, is it not?
This property,
These apartments?
these would be rental apartments. The single family was on that first concept where we had 5 single family homes in the rear.
Okay, but these are actually apartments, am I correct?
Correct, 12 units per building.
Okay. And you say you went through the lid to get the density bonus?
No, those standards have been drafted by staff. They will go to the Environmental Natural Resources Advisory Committee, and then will come before you guys in the county council before they're formally adopted. So we're following the intent behind the design and standards, but those aren't in the county code yet.
Okay.
There's no current density bonus for
Right.
lid. They're doing this voluntarily.
Right. Well, I think the lid actually, and giving density bonuses kind of counteracts what the lid's supposed to do in the first place when we start giving density bonuses, because now we're putting more of an impact on the property. But that's my opinion, what it's worth.
I have a question.
Go ahead, Ms. Craig.
I'm curious about the square footage of these proposed apartments.
Sure.
It seems desperately small to me. I've lived in New York City before in a 625 square foot apartment that was 1 bedroom, and it was small.
Mhm.
And you're talking about 700 square feet for 3 bedrooms.
I do believe that's just the county standard. We didn't modify those from the zoning. They may be larger on the floor plan, but I don't think there was any modification.
Yeah, those are just minimums,
Yeah. Mhm.
but it's consistent with our standards.
Yep.
Okay. Is that it? Anyone else have any questions? Ms. Vogt, now these properties to the south and to the west of this property here are currently developed in a kind of large parcels, are they not?
The A3 is 1 acre size lots, I believe.
Yeah.
Yeah.
And so we're coming in with a PUD with a pretty good density there. Do you have a calculation on what the density actually is?
It's 8 units an acre.
8 units an acre,
Mhm.
okay. Okay.
And we did have a very good turnout from all of the adjacent residents in those meetings to discuss.
Okay. All right. If we don't have any other questions, we can see if we have any public participation to this. We don't? Okay.
Thank you.
I'm surprised
Right.
there's no public participation, actually.
Yeah. Okay, I'm going to close the floor for public participation, open up for commission discussion. I'm going to tell you my problems with this. It goes back to what I was discussing with staff originally. You're going to end up having an enclave right there. You've got the developing to the west and to the south that are currently developed to this property, and it's larger parcels. And we're going to come in across the street from them and put in a 3-story apartment building. Now, to me, if I was living there, I don't think I'd be too happy with that. And I know they say the City of DeLand's 2050 vision, but I feel that those of us that live in the unincorporated area, which this is, did not have any representation with the City of DeLand when they come up with this plan. So to take that in consideration, yeah, I get it. It's going to expand, but to develop areas that are already developed, that people live in the unincorporated area that don't want to live in this city. That's one of the reasons we live there. I just don't feel comfortable with approving this comprehensive plan amendment, much less the PUD. That's my opinion.
I agree with you on both counts.
I mean, they're putting in the 3-story apartment buildings across from kind of a rural setting in the unincorporated area of DeLand. And no matter what you say, there's an enclave there, and I do know there's discussion that the city encompasses a small area of the unincorporated area. Whether you want to go to this city or not, there's talk that going ahead and putting these properties within the city limits. And that there again, that's why. And we sit here and we talk about due diligence and we talk about property rights. I'm looking at the due diligence of the people that bought property around this and realizing that if they looked at the future land use, the density is not near as much as what we're trying to turn it into. And also, they buy in these areas so they don't have to have the smaller lots adjacent to them. So I have a big problem with it. I think those adjacent property owners, if they did their due diligence and now we're creating this, and I don't think it's favorable to their property or to them in general.
Well, I just have a quick question. This goes to staff. All the property owners, they were notified about this, correct?
That's correct, yes.
I'm just
The
wondering
adjacent property owners.
why nobody's objecting to this.
The adjacent property owners, the only thing that was notified to the community there was an orange sign in the front of that property.
Yeah.
As the applicant stated, they did have community meetings, so
Yeah, they had community
they can
meetings.
speak more on who
so-
attended if you need to.
I don't know what was attendance there or how many were in attendance. But there again, I can only tell you that I can't imagine if I was one of these property owners here. You know, it may be in something that they feel like are being forced upon them too. I see that happening a lot. And so they're just trying to get the lesser of two evils when they agree to something. And so I can't imagine someone, if I lived in one of these properties here in unincorporated Volusia County, that I'd want a 3-story apartment building going in across from where I lived. In that rural setting. It's a rural setting. If you drive out there, you can see how large these parcels are, and most of them are developed. So that's just where I'm at. But I'm one vote.
Indeed. Every vote counts. Prepare to make a motion and move this forward.
Okay.
Ready?
Yes, sir. If there's no other discussion.
Yep. Anybody else? All right, so let's start with the first one, the CPA-24003. Make a motion that we find the future land use amendment consistent with the comprehensive plan and forward the application, case number CPA-24-003, to the county council with a recommendation of approval to transmit to the Florida Department of Commerce for expedited state review and to the Volusia Growth Management Commission for certification.
Second.
Okay, I've got a motion on the floor to find the future land use amendment consistent with the comprehensive plan and forward the application, case number CPA 24-003, to the county council with a recommendation of approval to transmit to the Florida Department of Commerce for expedited state review and to the Volusia County Growth and Management Commission for certification. From Mr. Costa and a second from Ms. Shelley. Any more discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Aye.
Roll call. Roll call.
Roll call, please, Ms.
Member Craig?
No.
Member Shelley?
Yes.
Chair Mills?
No.
Member Costa?
Yes.
Member Patterson?
No.
And Member Sixma?
Yes.
It is a 3-3.
Okay, we have a 3-3, so how does that go forward?
So you can, you have the option to continue it. The rules do provide for comprehensive plan amendments, and this only applies to the PLDRC. You need a minimum of 4 for recommendation of approval. So the issue is we currently don't have a chair appointment, and I'm not sure when that is going to occur. So you can continue it, but I'm not sure if the votes would change, or you can ask for any additional votes if anyone wants to change their vote. Absent that, it goes on to county council on a technical denial for failure to obtain a majority vote.
Then that's
With a
fine.
recommendation of denial.
So it's a technical, and that's up to county, it's council to either reverse it or
Yes.
go from there. Got it. I'm okay with that.
Mine too.
Everybody's okay with that? Okay, we're going to move forward with a technical denial because it's a 3-3 tie.
All right.
Okay, then
Next
we
one.
have to consider the PUD.
Yep. Case number PUD-24003. Make a motion that we forward the rezoning application, case number PUD-24-003, to the county council for a final action with a recommendation of approval.
Second.
Okay, I've got a motion on the floor to forward the rezoning application, case number PUD 24003, to county council for a final action with recommendation of approval. From Mr. Costa and a second from Ms. Shelley.
I would suggest
Any
a roll
dis-
call vote.
Discussion on the motion. We're going to talk about discussion on it
All right.
first. And I strongly disagree on the PUD now, even if the minor land use amendment was approved. Put a 3-story apartment building in front of a rural setting. I just can't imagine living there and having to deal with that, but that's me. So anybody else for discussion?
And I'll talk with you on that. And I typically, where I stand with these kind of things, but when you have multiple community meetings, more than one, and they basically retooled what they were originally going to put up there and retooled to this one with, it sounds like no opposition because there's no one here. So it's, whether the sign was there, posted on the property and the adjacent owners were notified, everyone in that community meeting, I'm sure, was aware of where this was going and how it was happening. And there is not a single person here, neither a letter of opposition nor a person here not opposing. So
I know that's where I stand with you on that.
kind of where I stand
also.
with that
Yeah.
one. I mean, had we had 5 or 10 people in the gallery that said, hey, yeah, we attended it, and yes, X amount approved it because we had no other choices, then I might be in a different position, swayed. But in this particular case, and I understand where you're coming from, I really do. That's my discussion.
Well, I haven't discussed it with the people that live there, but I can assure you that I know of at least 2 that would not want it, and that where they're going to be living. And one of them is directly in front of this project here. So, I mean, that's just where I'm coming from. I don't know what happened at the meetings. I don't know what the discussion was. We don't have minutes of the meeting. We don't know what was said. I can only tell you from knowing someone that would buy this kind of acreage in this area and develop it to have a rural setting. Put yourself in their shoes. That's all I'm saying.
Absolutely. And well, they have the option to go to council now. I mean, you've got a technical denial on the first one, and I'm going to assume that's going to be similar on this one.
I would have to agree with Chairman Mills on this one, that by the time, I feel like by the time it gets this far in the procedure, most people feel like they have no say, and what's the point in going to speak? So I have a real problem with this increased usage.
Okay. All right. Any other discussion on the motion? Okay, we'll go have a roll call on the motion. Ms. Tucker, could I get a roll call?
Absolutely. Member Craig?
No.
Member Shelley?
Yes.
Chair Mills?
No.
Member Costa?
Yes.
Member Patterson? And Member Sixma?
Yes.
There's a
Technical
3-3.
Okay, we'll go with the technical, can we, that takes 4 to.
That one only requires a majority.
Yeah.
But it's still a split vote, so there is no majority. If there are no other motions taken to amend some of the conditions, and it will also move forward on a technical denial.
Okay. Is everybody in agreement with that, to move forward with technical denial?
Yes.
I think that's what the
comfortable with it.
general consensus is. Okay. All right, we'll move on. Ms. Shelley, could I get the next case, please?
I've got, yes. Case number excuse me. O-25-005.
Wait a minute, we got another PUD.
PUD.
Okay, well, that's what I was looking at. Okay.
24008.
And then it confused me. Okay.
008.
All righty. Case number PUD-24-008, or 008, a rezoning from the transitional agriculture A3 zoning classification to a planned unit development with a business subclassification.
Thank you, Ms. Shelley. And Mr. Shams, this one is yours.
Hi, good morning. The applicant is requesting a rezoning for 2 contiguous parcels that are approximately 11.42 acres in the land area from A3 to PUD. The rezoning will legitimize existing uses on site, which include a contractor shop for the pool company and material storage and sales for the stone company. The applicant is not requesting an expansion of existing uses. Currently, the 2 uses are not permitted within the A3 zoning class, and a code violation for the uses was filed against the applicant in December 2021. The applicant is proposing the PUD to resolve the nonconformity and continue the uses. The site is located on the north side of State Road 44, or New York Avenue, approximately a quarter mile west of the city of DeLand. Property itself is developed with a 1,768 square foot structure with an in-ground pool that was originally a single-family residence built in 1940. It's now used for the pool company with point-of-loss systems. There is also, in the east side of the site, as you can see on the diagram, a 4,200 square foot accessory structure, 3 sheds, a 1,536 square foot accessory structure, and a rock yard with 3 material storage areas. These structures are used by the material company, Volusia Mulch and Stone. The materials sold are not excavated on site and are brought into the site to be sold. These uses have been active on site for over 18 years. The site is nearly surrounded on all sides by other A3 zone parcels. The parcel north and west is a 5.8 acre site developed with a single family residence, and the parcel north and east is a 20 acre timberland parcel. The area along the southern boundary is a large undeveloped set of parcels, approximately 126 acres, zoned as the Village of Pelham Park, PUD. This is part of the Sunrail Activity Center and will be developed with 648 residential units. In addition, the site is within the City of DeLand's emerging Gateway Corridor on State Road 44 and is subject to their buffer requirements on the southern boundary. There is currently a material storage area within the 40-foot landscape buffer that's required by the city. The city reviewed the project and requested the standards are met as much as possible. The PUD development agreement reflects this request. The landscape buffers include the following: 25 feet along the northern, eastern, and western boundaries, And on the southern boundary, with the city requirement, the buffer shall be 40 feet wide from the east property line to the material storage wall, 32 feet wide along the material storage wall, and then 40 feet wide again from the west property boundary to the material storage wall. So they're going to meet that as much as they can, and it's about 32 feet, just to summarize. The applicant is not proposing to expand the site's current operation, and existing uses will continue if the PUD is approved. Therefore, there is no change in trip generation for the site. Volusia County Traffic Engineering reviewed the proposed PUD and did not express concern, as there's no change in trip generation. Overall, staff recommends forwarding to the County Council with a recommendation of approval, and I'm available for comment or question.
Thank you, Mr. Shams. Any questions for staff?
Yeah, what brought this forward? Just
The code violation.
code violation?
Yes,
Got
sir.
it.
Okay, Mr. Shams, this has been in business for quite a while, though, has it not?
Yes, sir.
And also, what was the reasoning to do a PUD instead of a rezoning to B5?
So everything around this site is A3, and we didn't want to introduce spot zoning, so the PUD allows them to incorporate their permitted uses, the ones that they have on site already, and not open the door for anything else to come in the future.
And what is the future land use on this?
The future land use is rural.
Okay. Okay. Is the applicant present?
Good morning.
Good
I can
morning,
still
sir.
say, as the last item before lunch, other than your administrative items, I'll speak quickly. For the record, Mark Watts with the law firm of Cobb Cole, 231 North Woodland Boulevard, DeLand, and appreciate the staff report and recommendation. We've spent a lot of time working with staff on this. Incidentally, this is not the first time this particular site has been before this body. 1988. My dad actually represented LJ Michael, bringing this forward to get a special exception approved for processing, packaging, storing, retail and wholesale sales of agricultural products not raised on the premises. It started out as a mulch yard, landscaping materials, mulch yard, things of that nature, and really what's happened is it's evolved over. The Michael family sold it several years back to our current client. They've continued to expand it. It still operates as, it's where I go to get my, gravel, rock, and things of that nature for our house, our business. But it has grown beyond the scope of the special exception that was approved back in 1988. At present, there's both the landscape material operation that's on the site. There's a office that is basically a pool contractor that sells pool installations from the site. We've been working with staff really just to kind of take a snapshot of the things that have evolved over the past almost 40 years, or about 40 years, I guess, right? A little bit less, and allow that to remain. Mr. Mills, to your question on the land use, I think our initial conversations were to come in and actually apply to go to a commercial land use here. Staff had concerns about opening the door that wide up, and so since PUDs are conditionally, consistent with the rural land use classification, and this type of use really kind of fits well in this area along a main corridor like State Road 44. We worked with them to kind of encapsulate everything with the current rural land use into the PUD that's in front of you today. So moving forward, we would have to come back in for, as mentioned, this kind of started with a notification from code enforcement that, hey, I think you've gotten a little bit beyond your original approvals from 1988. You should probably do something about that. And we've been working with them to move this forward ever since. So what we'll have to do from here is move into site plan. There are some additional buffers and everything that will have to be established and maintained. We'll probably be shifting some things away from the edges of the property to allow those buffers to be installed and maintained. But this is kind of that first step. So happy to answer any questions you might have. Other than that, I've got nothing.
Okay, any questions for the applicant? Except anytime they change the ownership, we'll be back in front of here changing the PUD.
If there's the way that we set this up was intentional, because there could be future growth or expansion here, but the way that we've set this up, we'd have to come back and amend the PUD to come.
Yeah,
really just takes a snapshot of what's there now to legitimize everything.
Right. That's why I just couldn't understand why I didn't go to B5.
Yeah, understood.
Of this, but anyway.
That opens the door a little bit wider, and
Yeah.
particularly with the A3 around us, we thought this was an appropriate step.
Okay, okay. Any questions for Mr. Watts? Okay, do we have any public participation for him? No? Okay, we'll close the floor for public participation. Open up commission discussion or motion, and I will tell you that I'm familiar with the property, and it doesn't look a whole lot different than it did 20 years ago.
I'll be glad to make a motion.
Okay,
I move that we forward case number PUD 24-008 to the county council with final action with a recommendation of approval.
Second.
yeah, I got a motion on the floor from Ms. Shelley to forward the rezoning application, case number PUD 24-008 to the county council for the final action with recommendation of approval. And a second from Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously.
I note with a unanimous decision, so.
There you go. Okay, Ms. Shelley, could I get the next case read into the record?
Okay. Case number O-24-005. Ordinance number 2024-16, amending Chapter 72 of the Code of Ordinances to allow the shipping containers as an accessory structure in certain zoning classifications and establish regulation for use of said structures.
Okay, thank you, Ms. Shelley. Mr. Ashley, it's good to see you again,
Good
sir.
morning. How's everybody? Scott Ashley, zoning manager for Volusia County. What we have before you today is an ordinance that is to amend Chapter 72 to allow for shipping containers as an accessory structure in certain zoning classifications and to establish regulations for said use. County Council directed staff to look into the issue of allowing shipping containers. One of the issues that started this was in agricultural areas for use as an option for storage on agricultural properties. Also, they questioned about industrial and commercial properties. So staff had took the information from council and their directive, and we came back in October of last year with an agenda item for discussion on the current status of the code and an analysis of what could be done, some options for them, and address certain things like location, security, and or screening of these type of these shipping containers on these properties, and also look at some of the areas where they would like to see these, where would be the appropriate zoning. So we took that information and directed from them to create the ordinance, which you have before you today. And again, what we're looking at is changing to Chapter 72, Article 1 definition, and Article 2 of the zoning ordinance. We'd add a definition for shipping containers. We amend the definition of accessory structure. Also add a new code section, which would be 72-310, to establish specific regulations and requirements for the placement and use of shipping containers in the unincorporated area of Volusia County. And right now, shipping containers are not permitted, and that's based on our definition of accessory use and structures, which does not allow any conversion of any type of rail car, semi-trailer, and things that are similar structures which we deem the shipping container to be, cannot be converted or made or altered in any way to make it an accessory structure. So we have to go through and look at amending that definition, which we propose in the ordinance, to address that issue where you can't have shipping containers unless expressly permitted by code, because we are limiting where the location of shipping containers could go by zoning classification. And so basically, like I said, we're amending the code to add section 72-310, which is highlighted on, starts on page 4 and really gets into the meat of it, if you will, on page 6 of the agenda item, goes to page 7, where we establish certain standards and zoning classifications where they will be permitted, address things such as setbacks, compliance with the building code, getting a permit, also location on the lot, making sure it's, ensure that it's an accessory item, that it be back behind the front facade or plane of the home, as well as make sure it's screened. We do want to make sure it's placed on the property that has an existing structure. We're proposing limitations on the number of shipping containers that would be allowed. Also, they cannot be stacked or installed underground. This would be for storage purposes only. We're not proposing, or the code would not allow it to be converted to be used as a living quarters or workspace unless they go through the full Florida Building Code provision to convert it to a dwelling. Shipping container as a storage structure would not have any type of utilities attached to it. Also, location-wise, make sure it's not located in any parking lot, drive aisles, or pedestrian areas. Specifically, that would apply more to commercial industrial areas. And with the first part, and if you see below and on the screen, these are the zoning classification we're looking at based on discussion with the county council. There are agricultural areas, and the ones that are listed there, your commercial ag, as well as your rural agricultural or rural zoning classification that permit ag type uses on a personal nature. Commercial, which are B3, B4, B5, B6, and B7. Those are variations of either general commercial, heavy commercial, highway, or marina. And then they would also be allowed in all industrial zoning classifications, I1 through I4, and also any non-residential plan unit development subclassification, which would allow for business or industrial PUDs. I do want to let you know this has been an on-working document for a while, so unfortunately bringing it today and looking at it again, there are some grammatical and some staff changes that need to be, corrections need to be made, and there are simple things. We do reference the code one way, and we say 72.310. That is the intended code section, but if you look at page 5 of the document, we reference section 311. Unfortunately, that was the original section we were thinking it would be placed in, so it does need to be corrected there. Also, the zoning that's listed for the mobile home is not, it should be mobile home MH3, not 5. And also in the document itself, it should say I1 to I4. Unfortunately, it just says I, so we're clearing that up. Also on line 32 of page 6, under subsection 3 or II, that should be building permit, shall include a sketch plan. And the other corrections are, like I said, grammatical. There's a period here, there's an extra word, it's not necessary. Also, I did want to point out, we did receive some comments from an interested party. The gentleman's here today to probably as public participation, but I would, there are several aspects of the ordinance I believe you got a copy of, he's made comment on. Some of the things that staff would be agreeable and would address is on page 6 under the definition. On line 4, he's suggesting it be the term shipping container is synonymous with cargo container, Connex box, and so forth. The code has a mixture. It says the term, and it specifies the term, like shipping container, or it just says the term is synonymous, or it is. Staff has no preference. We'd be amenable to say the term is synonymous or the term shipping container is synonymous, if whatever your pleasure may be on that issue. Also on page 7, it would be line 4. The public is suggesting a change where the line sentence says they shall not be visible from a public right-of-way. The suggestion is to change it to the word street, which staff would also be agreeable to, because under our code definition, street covers all type of road, whether it's public or private, and then just not limited it to a to a public right-of-way as stated in code. A street would cover all those issues, and we would prefer probably that term as well. Beyond that, I'd be happy to take any comments or questions at this time.
Okay, Mr. Ashley, thank you. We do have some questions. Mr. Costas, let you get going. He's got a bunch of them for you.
All right.
Well, let me start by saying that there's no way that I can even remotely approve what we presented here today. So, and let's go down the list of why. I'm going to go through your analysis because it's easier to basically touch on that than the, like I said, you had some typo errors in the actual ordinance itself.
Yeah.
So RA and RR are actually included in the ordinance, correct?
Yes, sir.
RA and RR, correct? But you should also have MH3 as opposed to MH5.
Correct.
That's a correction as well.
Yeah.
What about RC?
RC is not a principal. That's something we looked at. That's primarily a residential. It's not an agricultural classification. Other than for pasture, all other agricultural uses are a special exception
Under RC.
under RC.
Okay, and what about MH8?
MH8, that is also a rule we could add that because that is a rural mobile home zoning.
And what I'm looking at, I think we should include all the rural and agricultural zonings that are greater than that are an acre or greater. I think should qualify for these
That
storage
was the
containers.
purpose from council.
Okay. Then the next one that I have a real issue with is that they must have a building permit and comply to the Florida Building Code. Now you have put an exception in here, except for bona fide agricultural lands. So when you say bona fide agricultural lands, are you talking about ag exempt lands or just lands that are, quote, under the ag umbrella?
Well, that would be the ag exempt lands.
Ag exempt lands only. All right. So therein lies the issue. So we've got probably, I don't know, hundreds, maybe thousands of these units, these containers all over the county. A lot of them are in some of your 2.5 acre parcels that are not ag exempt, but yet are still being used in an agricultural environment. And that's where I have the problem here, is that you're basically forcing these units that have been in peaceful existence all this time into complying with Florida Building Code and Fire Code for something that's actually being used for an ag purpose, even though it's not a for-profit. It's still a not-for-profit. It's a hobby farm, or it's a fruit stand, whatever the case may be, but it's not an actual for-profit. It's a in-home type of issue, and we're forcing them now to go through this permit application. I have an issue with that. Let's talk about, let's see if I can keep focus here. So, as far as the structure goes, especially you have, you're calling out that they have to be in conjunction with a principal use, which knocks out any kind of open pasture scenario, potentially feed stores. I guess that's under the business classification, but let's say open pastures where some of these are actually stored, and they're using them for storage of cultivated hay, potentially feed for the cattle, and so under this provision, they would not be allowed on those open pastures that don't have a primary structure, unless they are exempt under the ag umbrella. Once again.
Yeah, that's correct, because this is will be an accessory structure in use. And by definition, they are clearly incidental and subordinate to a principal use. So what is the principal use of the property?
All right. And let's go down to the maximum of 2 containers per lot or parcel. I think that's too vague. I would like to see that to be revised to say a maximum of 1 unit per 2.5 acres and under. And if you're larger than 2.5 acres, then you should be allowed to have 1 container per 2.5 acres. So if you've got a 20-acre parcel, you can have up to a maximum of 8 containers. And I think you'd still fall within the overall guidelines of maximum coverage. With 20 acres, you've got cattle scattered here, there, and everywhere. So I think that sets a limit as opposed to just 2 per across the board.
And is this strictly for ag or for all the zonings?
Well, I think that it depends. I mean, there's a fine line between bona fide ag and non-ag exempt properties that are still being used in an ag environment, and I'm not sure how we can address that here.
Oh, no, well, because we're proposing in commercial and industrial, so that's one of.
Well, in commercial industrial, that's another different animal, right?
Okay, so we break it up.
So
in
I'm
different
talking about,
sections.
I think that I'm talking here strictly about from the ag community, not so much from the business community standpoint. As far as located behind the front plane, on the commercial industrial, I have no issue, but it doesn't necessarily comply when you're talking on the ag property. So as long as it doesn't apply to the ag properties, I have no issue with that comment. And I'm going to go with the way it's written. So there's no permit required for ag exempt. But down below you asked, it says it has to be screened from the public right away. Are you also exempting ag exemption there, or is ag exempt required to put a screening system up?
They would also be exempt because it falls under non-residential farm building on a farm.
Ag would be exempt.
Statute.
Perfect, because that was, if not, that would be another way of basically forcing now agricultural to go in and get permits. One of the last ones are actually, no, not quite the last ones, but the other one I've got here is that the location of the unit itself and the placing of the unit. Why are we requiring it to be placed on a concrete pad or an asphalt pad and not just dropped right on grade like most of these shipping containers are being done currently? What is the purpose there?
Well, the purpose there is to provide a foundation for it, and part of the building permit is to have it, make sure it's secured to the ground. Just like any type of structure, we're not going to get a building permit so much for the structure itself because the container's already built.
Mhm.
It's more for the fact that you're going to anchor it to the ground. What is it? How are you securing it to the ground? So it doesn't move around or in kind of a storm, because we are in a coastal county. We have to meet wind load standards, and so that's the purpose for that.
Those containers they're not going very far anyways, but the question then is this also apply to the ag exempt or just the non-ag?
The ag exempt is excluded from
all of
codes.
this?
Yes, sir.
Okay.
That's state statute.
So that takes care of all of those issues then. And then so the provision about it for storage purposes only, and I think you touched on it earlier. If these units, I've seen these units used as affordable housing dwellings or business offices, if you will, in other states in general. So if someone wanted to convert this unit into a living quarters, then they would have to go through the full Florida Building Code. In other words, we're not eliminating that possibility here, are we?
Well, the goal is that this would be, if your purpose of the ordinance per council was allow for storage use, and so we didn't want them to convert it.
Okay.
If it's going to be storage for living, unless
Okay.
you went through that full process. So
All right.
don't convert it into something and without that process.
Okay.
Basically.
And then the comment about running either water or electricity to the unit. Now, when you use the word connected or run to the container, that's what threw the flag up on my end, because I would like to see that provision, as long as it's not inside the unit, that you're not putting power and water in the unit. I don't see any reason that you cannot run power to the external side of the unit for either a nighttime safety light, so you can actually still operate and load and unload, and the same with water. Again, if it's being used in an ag situation, water becomes an issue where you've got tractors to wash it or equipment to handle. I'd like to get that particular line stricken there. That if it's not fully attached or internal to the unit, I don't see an issue with that, with being able to run water and power to it.
Okay. And our concern was there, just like any structure that starts as an accessory, you start adding electric and plumbing, next
Right.
thing you know, you got a home.
That you got once it's on the inside, it's a whole different animal. I completely agree with you.
So
I agree with that.
So the language is good as long as it's referenced and not inside. the unit.
Yes, exactly. We're talking about strictly the interior of the unit.
Gotcha.
The off-street parking, I don't have a problem with. Not to be stacked, I really don't have an opinion at this time, even though I think that they have the potential of being stacked, especially if you're turning them into a dwelling of per sorts. But that would be a building code issue. So I'll leave that one alone. On the prohibited in the rights-of-way, public sidewalks, and the easements, a lot of these are being used for temporary storage. For instance, the building of a house or the building of a barn. I don't see an issue of it being, if it's in a temporary position, being placed in the easement itself, especially if it's a power line easement. I don't see the harm there. Public right-of-way and public sidewalks, I definitely agree. But in a power line easement, if it's there for 365 days or less, why would that be an issue? These are questions and statements at the same time.
Okay.
And then the prohibited on vacant or unimproved land. That goes back to my original question about if we got pasture field, it's vacant. I mean, it's not vacant. It's got cattle on it. It is unimproved, and the fact that there is no other structures, I want to make sure that doesn't eliminate the possibility of being able to have those units on those types of lands. They can't be used as a sign, I agree. Can't be rented or leased out, I agree. And then the other thing that's missing here is once this is completed and passed, if it was passed in its current form, you basically put hundreds, if not thousands, of users of these in the direct crosshairs of code compliance right off the bat. There is no provision here for either grandfathering them in as is where is, and or allowing for an existence of time for an appeal or a waiver without code enforcement coming down and basically slamming the hammer because now we've got an ordinance. How can we address that situation?
Well, right now, they're not permitted, but as far as the ordinance, I would refer to,
Well, they're not permitted because they don't exist
well,
in your code of ordinance.
right, and therefore they're not permitted.
Right, so all these shipping containers that are not, part of a storage yard or something like that, technically not allowed to be there. So I think we've received some complaints and we've dealt with, if someone puts a very obvious shipping container in front of their yard, that's a, automatic violation. But it falls back to, we're a reactive code enforcement type community, and no one complains when it's kind of out in, a lot of large agricultural lands. This was primarily designed to accommodate for your more obvious zoning districts and industrial and commercial establishments, but we didn't want to tailor something for those non-residential uses without also addressing, the obvious agricultural component of it. So technically, they're not allowed. This just kind of gives a way for us to formally approve them.
Well, it definitely gives you a way to formally basically start charging for permits and quite a few other things in here. And we're talking about, we're not talking about 5 or 10 units. We're talking hundreds, if not thousands. And I'm sure you guys are aware of that. We've got to have some kind of provision here to give these people an opportunity to, what you're asking for will not happen overnight, cannot happen overnight. And the majority of them are in agricultural positions, but not the majority. But I wouldn't say that all of them are in a ag exempt classifications. There are some that are in non-ag exempt classifications, only because they are not for profit ag operation. And that's the nuts and bolts of what I have a problem with this. Not so much. I mean, they're not going into residential units, into residentials, because if we limit this to a minimum of, I'd say an acre, but I'd be comfortable with 2.5. Nothing less than under 2.5 acres can have a storage unit. On an acre, a storage unit takes up, you're going to see it. Yeah. But on a 2.5 acre parcel that's still basically a hobby farm, if you will, I think that would be permissible. And on as we go on up. So those are my comments and my suggestions on this one. I think that it needs a little bit more tweaking and how to address that ag exempt versus the non-ag exempt, but still being agricultural. How do we address that and define that? And I don't have that answer today.
Okay.
That's it.
Okay, along that line with Mr. Costa, and Scott, you and I have discussed this many a time previously about the bona fide ag. The bona fide ag definition doesn't necessarily mean that it has to have an ag exemption classification. Bona fide ag means anything that's related to agriculture, because the agriculture exemption is tied to a commercial use. You can't get an ag exemption without a commercial use. So if someone is raising cattle on a piece of property that's zoned agriculture and they're within their rights to do so because of the zoning, would that not be considered bona fide ag?
Well, with the code right now, as you just pointed out, if they have an agricultural exemption, that's a tax thing from the property appraiser, and it's built in the statute, allows it, they're automatic. Just because you have agricultural property doesn't mean you get to do a building without a permit automatically. That's where the bona fide ag, because we do have the non-residential farm building on a farm affidavit process where the property owner would show and detail to us they have a current use, because that's where the statute gets into. Do you have a non-residential farm building on a farm? Is there an activity occurring currently to justify you to have an exempted structure on the property that's being used for agricultural purposes? So, and that's what we have we have that process now. We handle that. If you don't have the agricultural exemption, that's your other process. Show that you have an agricultural use occurring, and with that, you submit an affidavit. It's not a permit, it's just a placard for tracking to show that in case there are issues in the future, that building is there because they had an agricultural use in accordance with the code provisions that we have.
Okay. Along that line, you said this is where I think that when you buy a piece of agricultural property, you would assume that you can use it for agricultural purposes. Anyone purchasing a property adjacent to it or around it would assume that they can be used as an agricultural property. I don't know why we have to go through the bona fide agricultural use on agricultural property when it's got a designated zoning as agricultural property. And saying that, and the reason I say this is because let's say we go out and I want to put on I got an A1 zoning and I want to raise 300 chickens. Just to say I wanted to do that. Because I wanted to raise these chickens and I wanted to sell the eggs, but I'm not going to sell the eggs there, so it's not a commercial use. So I go down the road and I sell my eggs to my neighbors, but I got to build a building to put my chickens in first. I can't get that agricultural exemption. In other words, I've got to go through the building permit to build a chicken coop. Okay? So my point is all along, and like I said, we've discussed this many times before, and I every time I have an opportunity, I'll bring this up. If you've got an agricultural zoning and everybody assumes you can have an agricultural thing, why do we penalize agricultural zone property? We do it on our setbacks. If it's an agriculture, if you got an agriculture exemption, you don't have the setbacks. If you don't have it, then you've got to meet a 40-foot or whatever setback it is to the property line. But the minute I make it an agricultural use and go through the definition of the bona fide agricultural use, I don't have these setbacks. I don't know why we're penalizing our agricultural zone properties in this manner. If it's zone agriculture and the adjacent property owners know that it's agriculture and know what to expect if they were to purchase it by agriculture, why are we applying these restrictions to these agricultural zonings? Maybe you can answer that. I don't know. But that's why I believe the bona fide part of it needs to be totally out of the code at all. If it's an agriculture and it's in, well, maybe one of the agricultural zonings, whether it's a 1 acre, but like Mr. Costa said, 2.5 acres and up. If you've got that zoning, then why are we defining because you do a bona fide agriculture or zone that, whether either or? You should suspect that if you were buying an agricultural property, and years ago that's the way it was. I know where this come about. Somebody had a piece of agricultural property and built a bunch of barns and stored cars in it. I know where it come from. And that's where this ordinance, that's where the restrictions come in. But one bad apple shouldn't spoil the whole basket. You know, I mean, if there's a way to manipulate it without going from one extreme to the other, because he was on an extreme. I remember when it happened, and that goes back a lot of years. And where it is now, way before I was on this board. But that's where this ordinance, I mean, the requirement come in for the bona fide ag and the ag exempt, come into the agricultural uses. Otherwise, if you had an A1 zoning, A2 zoning, I don't know about the A3, but if you had that type of zoning, you didn't have to do anything above and beyond what the bona fide agriculture would allow you to do. So I hopefully did open the door in this ordinance for discussion on this, because I've seen it many a times. Like I said, you and I have had this discussion many times. What's the definition of bona fide ag? I get it has to have an ag exemption, but that's not the case for a definition of bona fide ag.
No, it's the use. And when you look at the ordinances intended to allow an agricultural because of the acreage and sometimes the use, we're not regulating how it is used unless you tell us it's going to be used for agriculture, and that's where possibly the exemption or the non-residential farm building comes in. If you want it as an accessory just to store more stuff on your property, you have too much furniture and you need something to store it, you put on ag property, you could do it. That doesn't automatically make that an ag structure. And that's where the whole issue, are you using it for an actual agricultural purpose? That's where the state statute comes in too, all about is it intended to be used for that, then that's where the exemption language comes forward. So right now, I could use it for personal storage, I can put cars in it, it doesn't matter, as long as you can have a shipping container on your property, that's what we're allowing you to do. We're not regulating how it is used, unless you tell us, and again, the ag part, then that's where that exemption issue comes in.
Well, you're already limiting to how many you can have. So if I've got a piece of A1 property and I live on 20 acres and I want to put furniture or a car in one of these, why should I have to, why would that not be allowed?
Well, you can do it. I mean, right now, the number is there from the draft, because we looked at, in this county, only South Daytona and Holly Hill have regulations for shipping containers. New Smyrna Beach specifically prohibits them. None of the other municipalities say anything about them. So in our research, some places it's 2, maybe a little bit more. They haven't done it by the acreage situation. So we're flexible, you know, and certainly with your information, we forwarded an agenda item to council and make their decision. They didn't really talk, they did not get into the number per se. They just wanted to address some of the primary location on the property, where they could go, what type of zoning, what size of property. They did agree to some screening and how it's secured. But as far as the number, they did not get into that. We gleaned that from our research with a lot of the different counties. Pope County, for instance, is about a year-old ordinance where they dealt with cargo shipping containers. So that's where our research came from, getting the numbers.
Well, I get that, and I understand where you're coming from on this, and I understand where the council's coming from. But what I don't understand is, if it's got an ag classification, what difference does it make if it's bona fide or not? As long as the acreage meets the minimum requirement. We can put a minimum requirement of 2.5 acres on it. Why do it necessarily have to be a bona fide agriculture to get the exemption? Why can't it all be the same if it's an agriculture zoning?
Well, that kind of gets into a bigger discussion, because then we'd have to open it up to other accessory structures.
Exactly.
And right now, the code only permits, well, if you have a home, you have an accessory structure. Section 72-280 deals with more than one principal structure. If you have agricultural property, you don't have to have a home to be a principal structure, but it does have to be an agricultural building, and defines what those are. A barn, your silo, or some other agricultural use building is permitted, and without a principal residential dwelling. But it gets back to, okay, is there an ag use now? No, you need a building permit. Or you do have an ag use, or you have an exemption, then you don't have to do a building permit.
Well, the thing of it is, if it's zoned agriculture, what difference does it make?
Well, we'd have to address that obviously separately, because then we're affecting beyond the scope of what we're proposing now.
Right.
But it sounds like
this is a discussion. This
Right.
is the reason I'm bringing it up, because this is one of these instances where this applies. My point, whether my point's valid or not, that's for somebody else to decide. I don't make ordinances, and I'm not the final decision on the ordinance. But my point has always been, why are these agricultural zone right there in itself gives the classification of what you can do there?
Yeah.
Why is more penalized? Some of these agricultural, well, they are. Agricultural zoning is more restrictive than residential. Why? But if I got an ag exemption, it's not at all.
And I do clarify.
That doesn't make sense.
Yeah, your FR, A1, A2, A3, and A4, and MH3 are your only commercial ag zonings that this is going into. Your MH8, MH4, your ARR, and RA are personal use only. So we have to, it's almost like a breakdown, it's a different distinction. Agricultural properties per se, rural properties, and then commercial industrial somewhat, or just have a blanket exception type language. Excuse me.
I'm
That's what I'm trying to get some thoughts from you.
Properties, though. That was my point.
Okay.
I'm not saying move it into the MH5 or whatever, but the point of it is that what I'm saying is, on your agricultural zone properties.
Okay.
And not just this ordinance here, I'm looking at a broad view.
Sure.
Of the, because I bring it up every time when I sit up here, and you know that.
Yeah.
You've seen me here many years, and I always bring it up, and I don't miss an opportunity to do that, because I think there needs to be some discussion on that.
Okay. We're just looking for feedback, because this, either your decision today, whether or not you feel it's not ready, you continue it, or if we go forward with council, feedback for us to present to council. These are your findings.
Well, we
your
do have a
issues.
public participation form. I'd like to hear what he has to say on
Sure.
this, and then what we'll do is make a decision. I think a way, if I've got the temperament of the board here, is to continue it and let you go back and work on it.
Okay.
Okay? All right. I do have a public participation form from Mr. Nagel.
I gotta say, this is like old school seeing you guys here with Pat and I up here. Go back many years.
Good morning, sir.
Good
Name
morning.
and address for the record, please, sir.
My name is Christian Nagel. I live at 350 Stillbrook Trail in the wonderful community of Enterprise.
All right,
And,
sir.
I've lived in unincorporated Volusia County for 18 years, and Volusia County itself about 30 years. I'm here before you to speak about the ordinance. I just learned today from Mr. Ashley all the effort that's went into even creating this document, and I commend that effort. I didn't, especially since the county council has given their views about what they'd like to see in the ordinance. So this particular ordinance, I'm here to speak about. I think that a lot of effort's went into it. But I do think there needs to be some further refinements to it. I'm sorry I didn't get it to you, to the staff yesterday, but I've only knew about the ordinance for about 4 days, the proposed ordinance. So I gave to the secretary the other day some pretty extensive comments, and I'm not trying to be proud or brag, but I've been fortunate enough I'm now retired, but I've got over 40 years of experience as a professional planner, and I've been a certified planner for many years also. So it's not like I'm not familiar with how ordinances are created and structured and wrote. I've been even fortunate to be involved in creating ordinance amendments for this very county. So, but I'm here today to talk about the things that I'm most interested in this proposed ordinance. I think that there's some amendments that need to be made. The main thing is, I got 4 main things, and I appreciate the feedback we got today that you're basically still working on a proposed ordinance for the regulation of these containers, because yes, reasonable regulations are necessary to regulate those containers. But the things I'm most interested in, despite all my comments that I submitted to you, the things I'm most interested in is making sure that they're not allowed in the RR, rural residential zoning classification. The proposed ordinance, it's got conflicts between which zoning classifications are going to be allowed in. But I'm sure Mr. Ashley would and the rest of the staff would address that. The second thing I'd like to be considered, is that there be a size limit, a size and height limit on these containers. The staff report talks about shipping containers, what they typically are, but there's no requirement in this proposed ordinance or no provisions for how big they can be or how tall they can be. The third thing Mr. Ashley already mentioned is that you're going to the ordinance needs to be modified so that you clearly list which classifications are going to allow the use of these.
Excuse me, you can shut that off. He's giving pertinent information, and I think we're wanting to hear what he's got to say.
Thank you. I appreciate it. I don't mean to be long-winded.
No, you're good.
But you clearly list which zoning classes are going to allow the reasonable use of these shipping containers. If you look in the whereas section of this proposed ordinance, there's conflicts between that section of the ordinance and the actual meat and potatoes part of the ordinance. For instance, in the ordinance as written would allow shipping containers in zoning. Excuse, give me a minute here, please. I'm sorry. Would allow shipping containers in the MH5 classification, which is the urban mobile home zoning classification. It would allow them in the RR zoning classification, which is clearly a single-family residential classification, so that part of the ordinance just needs to be cleaned up. If you look at the whereas section, the listed permissible zoning classifications, those are good, but if you go in the actual ordinance, there's some conflict there that needs to be addressed. The third thing I'd ask for you to consider is that you not allow the placement of the shipping containers in the enterprise community overlay zone area as established by the county code. That is a special and unique part of the county. There are special regulations in the county code already. Talks about how the enterprise community overlay zone area should be used and protected as a unique place. And I'm asking for that consideration to be given. The county spent some law, has actually got a special part of their conference plan and their county code trying to protect the enterprise area as a unique and special place. So that's the other thing I would ask you to consider. If you need a map of where that area is, I've got an overhead to give you if you want to know which area that we're speaking of. And if you can't at least do that, at least do not allow these shipping containers in the designated historic district, enterprise historic district that's already established. And I've got a map of that one also for your use if you want to see it. So those are the major things that need to be done. But I commend the staff for recognizing some of the comments that I unfortunately only gave to them yesterday, because I always knew about this proposed ordinance for like the last 4 days or so. But,
well, let's go.
But I sure appreciate the ability to come here and speak. You get me fired up if you get me talking about rural residential zoning and especially the enterprise area, enterprise community area. Here, I've got maps for you.
You can submit it to Ms. Tucker and it become part of the record. Mr. Nagel, as you well know, pretty much the consensus is this is going to go back to staff for further review and some tweaks and things like that. So you'll have an opportunity to see the cleaned up version of it, I'm sure. I'm sure he can get that. Who can he get that from? Ms. Smith? Can he get that from you? Or Mr.
Are you
Ashley?
speaking of the map or the revised ordinance?
Well, when he cleans it up, well, Mr. Ashley, would he go to Mr. Ashley to get that, or
we'll
would he?
work with Scott to get that to Chris.
Okay, is that okay, Scott? Provide him a copy.
That would be wonderful, because
okay, even though it's published online, usually about a week beforehand.
I'd like to see it. I'd like to see it before then.
Okay, well, that's.
I'd like to see it.
You can request that for Mr. Ashley. I can't guarantee it, but you can definitely request it.
I'm just. I've got if need be, I gave the Kelly there the official maps of where the enterprise community overlay zone area is and where the enterprise historic district is.
Okay, we'll submit that and give that to Mr. Ashley so he can take that in consideration and then your comments in consideration.
Yeah.
And
thank you so much.
Helpful because this is a work in progress, and I mean, we're not going to make a definite decision today anyway. So.
Okay.
Okay.
Thank you much.
All right.
I didn't mean to talk your ear off, but it's got me going.
Okay.
In a good way. I
Okay.
commend all the efforts that Mr. Ashley and the rest of the staff make. They're very hardworking. They certainly do care about the
And your comments on the
citizens
ordinance have
of this county.
been submitted as part of the record, so Mr. Ashley, I have an opportunity to look at that also.
Thank you so much.
Okay? All right. Okay. Do we have any other public participation for this case? No? No? Okay. All right, we're going to close the floor and open up for commission discussion. And I think a general consensus is to send it back with Mr. Ashley and let him clean it up a little bit and bring it back. How much time do you need, Mr. Ashley?
I don't know what deadline dates.
60 days, 90 days,
That would be
Well, I'd say 60 days, yes.
60,
60?
which would put us at what meeting is that?
That'd be
October. October meeting, what does that fall on the third Thursday?
It would be the October 17th PLDRC meeting.
15? All right, so I'd like to make a motion.
Okay.
Case O-24-005, that we continue it to the October 17 meeting with the comments we've submitted to staff for review and change.
Second.
Okay, I got a motion for Mr. Costa to continue this to our October 17th meeting from Mr. Costa, and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion carries unanimously. Okay. That'll be it. Okay, any other public items?
No, sir.
Any staff comments?
No, sir.
Any commission comments?
I love the way staff works. I really do. I mean, you guys do a good job. Sometimes we're remiss in not acknowledging that, but you guys do a kick-ass job. And it's a thankless job, too. I can tell you that, because that's all I hear on the outside. Staff's this and staff that. It's like, you really should just go in and talk to them. They're really friendly people.
Some of them.
Helpful.
I wouldn't say some of them.
Yeah. Well, they don't have to agree with you 100% of the time, but yes, at least they'll listen.
Yeah.
Yeah.
Any other commission comments?
And Chris, thanks for all your years of service at Volusia County, too. Good job. Yep, thanks. You and Scott both, and Trish and all of you. We commend you guys.
Okay. The other comment I had is on one of the one that we had today on the CPA. I know they had a community meeting, but we don't know who was there. And when the only thing that the neighborhood has is a orange sign sitting out, and they know it's going to be developed, but I guarantee you 90% of them or 99% of them didn't know they were getting 3-story apartment buildings put in there. They think they're getting, this going to be another residential community there. And so hopefully the word to get out of what is actually proposed to go there, and they'll show up at the county council meeting. That's all I can say, I mean.
But they have that opportunity
Yeah.
to show up in county.
Yeah.
I thought the same thing as I was driving around looking at all the sites on here. And when I saw that one, it just kind of took me back. It really did.
I mean, I've been probably more favorable if it had been, I don't know about the densities, but I don't want to go there as far as that, but I'll just leave it at that. Okay? Press and citizen comments. This meeting's adjourned.